ಸರಿಯಾಗಿ ಮಾಡಿದ್ರು.
ಗೌತಮಿ ಅಂತ ಏನು ಬಂದಿಲ್ಲ ಇನ್ನ ಬಂದಿಲ್ಲ ಬೇಡ ಇನ್ನ ಬೇಡ ಬಿಡಿ ಬೇಡ ಹಾ ಕರೀರಿ
ಅದು ಮುಗಿಯವರೆಗೆ ತಗೊಳಲ್ಲ.
ಹಾ ಬಂತು ವಿಜಯಲಕ್ಷ್ಮಿ
ದೀಕ್ಷಿತ್ ಅವರು ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಈ ಅಮೆಂಡ್ಮೆಂಟ್ ಅದೆಲ್ಲ ಇಲ್ಲ ರೀ ಮೊದಲು ನಾಳೆ ಈಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಮೊನ್ನೆ ಅದನ್ನ ನೆಕ್ಕಂಟಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರಂತ. ದೀಕ್ಷಿತ್ ಅವ್ರು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ವ್ಯಾಲಿಟಿ ಜಾಯಿನ್ ಮಾಡಿ ಅದೆಲ್ಲ ಈಗ ಬರೋದಿಲ್ಲ ಹೋಗ್ರಿ ಅಂತ ಹೇಳಿ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ಅಂತ. ತಾವು ಏನ್ ಮಾಡ್ತಿದ್ದೀರ ಅಂತ ಕೇಳಿಲ್ಲ. ಅದ್ ಬರೋವರೆಗೆ ತಗೊಳಲ್ಲ
ಯಾಕಂದ್ರೆ ಡಿಬಿನೇ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಹೌದಾ?
ಸಿಂಗಲ್ ಜಡ್ಜ್ ಕಷ್ಟ.
ಏನು ಬರಲ್ಲ ಅದರಿಂದ
ಸೆಕೆಂಡಿಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ರು 23.
My lordship, being spoken, my lordship, pen recovery order is not coming forthcoming. Permit violation, my lordship. Permit violation. Pen recovery is not forthcoming. Judgment, my lordship. Tomorrow, my lordship.
ಕೊಡಿ ಜನರಲ್ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಕೊಡಿ ಸರ್, ಕೊಡಿ.
ಕೊಡ್ರಿ ನೀವು.
Page wise adjournment. List number 1, page number 1, serial number 1 to 6.
Serial number 6. Each time in the class.
Serial number?
I'm responding.
Which serial number?
Serial number 6.
Serial number 6.
I mean 6.1, I am the petitioner.
Is there any interim order? Yes, at the request of respondent. Release this matter next week. The interim order granted earlier is extended till last week.
Serial number 3, my lord.
Hmm.
Kindly have it Monday.
You are appearing for
Respondent. Petition is
Petition.
and for the petition.
petitioner. At the request of counsel for the respondent. Release this matter next week.
Please. Oblige.
Page number 2, serial number 7 to 10.
ಒಂದು ನಿಮಿಷ.
Page number 3, serial number 11 to 16.
Serial number 15, my lord.
Serial number?
15.
ಹಾಕಿದ್ದೀನಿ.
Mediation,
ಊಟ ಮಾಡ್ಸಕ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
local alert for settlement. my lord.
ಅದೇ ತೆಗಿಸ್ತೀನಿ ನಿಮ್ಮ ಹೆಸರು ಡಿಲೀಟ್ ಮಾಡಿ.
ಮಹೇಶ್ವರ ನಿಮ್ serial number ಎಷ್ಟು ಸರ್?
15
Yes,
may be sent to local alert for settlement. my lord.
yes, at the request of the parties, refer this matter to Lok Adalat.
Please.
Serial number 14, my lord, I am appearing for the appellant in this case, my lord. Even the insurance company has filed another MFA.
Which is that?
This matter may be connected along with that matter, my lord.
Yes. Counsel
And
for
called on
appellant
next
submission
week, my
that
lord.
78.
call this matter along with that. Yes.
Page number 4, serial number 17 to 22.
21, my lord. 21, next week, my lord. Serial number 21.
At the request of counsel for the petitioner, release this matter next week.
Serial number 19.
Serial number
19.
19. Yes,
Paper 1 week time.
at the request of petitioner, release this matter next week. The office objection compliance ಇದೆ ಅಲ್ರಿ? Week's time is granted to comply office objection. Have you informed the other side? Because his application is there. Then we'll see when the matter is called, we'll grant time.
213.
Yes, we'll see, yes,
213.
yes.
Page number 9. Page number 9, serial number 50 to 53. Page number 10, serial number.
Serial number 56, my lords.
Hmm.
I have informed the other side also.
Hmm.
Pray for second time, my lords. In second week of September, lordships may kindly have it.
You are appearing for whom?
Petitioner.
At the request of counsel
Interim
for the
order has to
petitioner,
be extended.
release this matter of 2 weeks.
I'm sorry, my lord. Serial number 46, mute ಆಗಿತ್ತು ಅದಕ್ಕೆ. ಅದು ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತೆ ಸುಮ್ಮನೆ. 46.
40?
46
46.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತೆ ಸುಮ್ಮನೆ.
Yes, office is directed to secretary from the tribunal, yes.
Serial number 55, my lord.
Please, ma'am.
One ನಿಮಿಷ ಇರಿ madam, page wise. So,
Hmm.
Page number 10, serial number 54 to 59.
Serial number 55, my lord.
55.
Settlement ಆಗ್ತಿದೆ, my lords. Next day can report ಆಗ್ತಿದೆ. 2 weeks.
You are
time.
appearing for?
Petitioner, my lords.
What is the settlement? In SC/ST matter, how can we settle, madam? It is a property of the state. Without consent of the state, how can you settle? Unless that your purchaser or a grantee.
Senior.
Yes, at the request of counsel for the petitioner, release this matter next week.
Serial number 58 ಅಲ್ಲಿ please, my lord. Kindly delete the Jwala Kumar's name in 58-1. Kindly show mine. I filed the no objection wakalat in that case, please.
Yes, office is directed to delete the name of Jala Kumar for respondent number 2. Show the name of Ravish Bini.
And put up my wakalat, please.
Your name directed to show your name. It's enough. They will show
Please, please.
Then what you want? You want to adjournment?
Please, my lord.
Yes, leave this matter next week.
Page number 11, serial number 60 to 64.
Let's serial number 60. I am for the appellants, my lords. Senior is quite inconvenience. It may be taken up in the next week, my lords.
60.
Yes, my lords. I am the petitioner.
Yeah, no, it is an MFA, Mister.
Yes, my lords. Sorry, I am an appellant.
Appellant.
Yes, my lords. Appellate.
Yes, at the request of counsel for the appellant. Leave this matter next week.
Page number 12, serial number 65 and 66.
Millet, serial number 66, millet, I am here for petitioner, millet, 2 weeks time,
Why?
millet, senior in,
At the request of counsel.
interim order to be extended, millet.
Leave this matter next week. Interim order granted earlier is extended till next date of it.
List number 1 for preliminary hearing, serial number 1. Irremated Maheshaya for petitioner.
Yes.
But petitioner is purchaser, my lord. My lord, the fifth respondent, grandfather of the fifth respondent was granting, my lord. After lapse of 58 years from the date of sale, my lord, he has initiated proceedings against the present.
The date of the sale.
My lord, date of the sale is, my lord, 6/4/56. Before commencement of act, my lord,
6/4.
1956.
1856.
My lord, proceedings initiated,
Is that Act 79?
yes, my lord.
When that application is filed?
My lord, 5/3/14, my lord, 2014.
What is the order passed by the?
My lord, order passed by the Assistant Commissioner is, my lord, annexure F, page number 29, my lord, operative course,
Restored.
yes, my lord.
What is that DCS?
This confirmed the order of the Assistant Commissioner, my lord.
How issue notice? Stay up. Order dated. Annexure? H
My lord,
and F.
annexure F, my lord, annexure F is
They
the
are
order of the
annexure
Assistant
F.
Commissioner, my lord. And annexure H is order of the Deputy Commissioner, my lord.
H and F.
Yes, my lord.
Stay of annexure H and F till next date of hearing.
Serial number 2, Somashekara
I
KH
filed-
for petitioner.
I filed an application for blood amendment. That's been not allowed because blood, in earlier, I have not challenged the validity of the new act. Now I am challenging blood in the application. That's blood.
Yeah, proceed. Yes,
And blood, this is the case blood.
yes, IA 1
And
of
the-
2024 is filed for amendment of writ petition. For the reason stated in that application, IA is allowed. Petitioner is permitted to file an amended petition.
Amendment is ready.
Official file madi. What is that you want, Mr.?
Blood, I want to stay blood because blood the grant blood in the year 1966. Purchase blood in the year 1968, not purchase during the exchange. Lands have been exchanged by the petitioner as well as blood the grandfather of the blood the respondent.
You are a purchaser or a grantee?
I am the purchaser.
Then what has happened?
Blood 1968 blood the purchase.
1968.
68. That Assistant Commissioner application filed in the year 2018.
When the application is filed?
No, 2018, my lord.
2018.
Blood 52 years there is a delay. Assistant Commissioner blood rejected his application.
AC is rejected.
Rejected. On the ground that blood, he has not produced the original certificate or grant certificate before the AC.
What is the DC?
DC blood the reverse the order of the Assistant Commissioner. Even blood, even before DC also blood, he has not produced any original records.
Yes. Out. Issue notice. Stay of
Annexure A, my lord.
annexure A till next date of hearing. Note.
Admission matter.
ಅದರಲ್ಲಿ ಕೊಡಿ ಅದು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಗೌರ್ಮೆಂಟ್ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಅದು ಇನ್ನೊಂದು ಮ್ಯಾಟರ್
1, 2, 3, my.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ is directed to take notice for respondent number 1 to 4, directed to serve 4 sets of copies, issue emergent notice to 5, 6, 7 and 8. First matter okay. Second matter
Only 1, 2, 3, my lord. 4 is a private respondent.
government advocate is directed to
First
take
matter.
notice for respondent number 1 to 3. Counsel for the petitioner is directed to serve 3 sets of copies. Stay of annexure A, issue emergent notice to R4. Yes.
Admission matter, serial number 3 adjourn, serial number 4, Bhagoji Vijay Kumar for petitioner, D.R. Sridhar.
Now, see, the petitioner is coming to Bangalore, madam. Matter has been settled. 15 days time. ಇವತ್ತು ಬರ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ ಬೆಂಗಳೂರಿಗೆ.
ಇವತ್ತೇನ್ ಇದೆಯಾ mediation?
ಏನು?
ಇವತ್ತು
ಅಲ್ಲ, mediation, my lord, I am the
Mediation ಆಯ್ತು ಸ್ವಾಮಿ, mediation ಆಗಿ ಕರ್ಕೊ ಬರ್ತಿದ್ದಾರೆ.
ಹಾ.
ಇವತ್ತು next 15 days ಅಲ್ಲಿ it will be
Yes, yes, what you want now?
date fix.
Yes, Mr. Rupesh, is it?
my lord, settle ಆಗಿದೆ. I have called them and I have told them that they are coming today,
We'll have it next week.
next week, my lord.
Yes, leave this matter next Wednesday.
Nice.
Serial number 5, Bharat K for petitioner, Ramesh Babu
Lord.
R.
Pradhan for the petitioner, my lord.
Respondent.
My lord, I am seeking a transfer. Petitioner
Yes.
is the husband from
Yes.
Malur Senior Civil Judge Court to Anekal Senior Civil Judge Court, my lord.
Hmm.
My lord, the petitioner had filed the MC petition in the year 2017
Hmm.
at the instance of the wife. This honorable court in CP 339 of 2017 transferred the matter from Family Court Bangalore to Family Court Malur,
Hmm.
Malur Senior Civil Judge Court.
Now, who has filed this MC petition?
My lord, the MC
Husband.
petition was
Husband.
originally filed by the petitioner, husband.
Husband, MC number?
MC number 5418 of 2017, my lord.
What is that? MC 36 of 2018.
36 of
Transfer.
2018 after the transfer, my lord. Renumbered as 36 of 2018 before Senior Civil Judge Anekal.
Now, which is that original MC number?
5418 of 2017.
17.
5418 of 2017.
Please, my lord.
Yes, it is filed in Bangalore.
In Bangalore, my lord.
Yes. Then why
Then-
it is transferred?
It is transferred at the instance of the wife, my lord.
Where is that order of this court?
My lord, page number
Yes.
84, my lord.
Hmm.
Page number 84. At the instance of the wife, this honorable court was pleased to transfer the matter to Malur.
Hmm.
In Malur, my lord, during the pendency, my lord, they filed an application for maintenance along with affidavit of assets and liabilities.
Hmm.
At page number 95, my lords, the wife admits that she is residing at Anekal along with the child.
90?
Page number 95, my lords, of the affidavit, of the petition, my lord.
Yes.
In the affidavit, my lord, she admits that she is residing in Bangalore. Anekal,
Where is the
Anekal.
affidavit? Where is that affidavit? 95?
Page number 95, my lords.
Yes,
Part-
95. Hmm.
Please, my lord. In the affidavit, my lord, she admits that she is residing at Anekal with a child.
Where is that, mister?
My lord,
There it is, Ulmangla, Hoskote village.
No, affidavit is page 94.
Lord, the application is at page number 91, my lords. The relevant portion where she admits that she is residing at Anekal is at page number 95, my lords.
Yes, 94 it is there.
Please,
He is
my lords.
aged about 32 years, resident of Pomanasandra village, Anekal.
Please, my lords.
Hmm.
Now, my lords, the distance between Anekal to Malur is, my lords, about 50 to 70 kilometers, which will
Anekal-
take to Malur, my lords,
Hmm.
between 50 and 70 kilometers. my lords.
70 kilometers.
Though distance is about 1 hour, but because of the traffic, it will take about 2.5 to 3 hours. My lord.
Hmm.
Now, the matter is set for cross-examination of PW1, my lords, who is the petitioner. My lords. He has been, the petitioner has been partly examined so far, my lords. If my lords are audible, my lords. Lords, there is some internet disruption. My lords, if my lords are audible, my lords. My lords, the my lords, because of the network, my lords is not audible, my lords.
From the beginning, she is ready to go with her husband, my lord.
Hmm.
but he is not ready. The reasons best known to him only.
No, we are not.
Now the cross examination is already commenced. Conclusion stage ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ 24th ಇದೆ cross examination.
Now that where you are residing now, mister? You are filing in a false affidavit before the court time and again.
ಇಲ್ಲ ಸ್ವಾಮಿ ಎರಡನ್ನೂ ಹೇಳಿದ್ದೀನಿ ನಾನು. ಪರ್ಮನೆಂಟ್ ರೆಸಿಡೆಂಟ್ ಉಲ್ಮಂಗ್ಲ ಹೊಸಕೋಟೆ ವಿಲೇಜ್, ಇಲ್ಲಿ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ಇರೋದು ಸ್ವಾಮಿ. ಅವ್ರೇನಾದ್ರು ಮನೆ ಕೊಟ್ರೆ ಅಲ್ಲೇ ಇರ್ತಾರೆ, ಬೇಕಾದ್ರೆ ಆಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್.
No, that Anekal, why you are staying in Anekal? Are you working there?
ಆನೇಕಲ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಶಿ ಇಸ್ ನಾಟ್ ವರ್ಕಿಂಗ್. ಮಗುನ್ ನೋಡ್ಕೊಂಡು ಅಲ್ಲೇ ವಾಸ ಇದ್ದಾರೆ ಅಷ್ಟೇ. ಅದು ಟೈಮ್ ಬೀಯಿಂಗು ಗಂಡನ್ ಜೊತೆ ರಿಯೂನಿಯನ್ ಆಗ್ಬೋದು ಅಂತ ಹೇಳೋ ಒಂದೇ ಉದ್ದೇಶಕ್ಕೆ ಮನೆಗೆ ಹತ್ರನೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಒಂದು ಬಾಡಿಗೆ ಮನೆ. ಈಗ ಇನ್ನು ರಿಯೂನಿಯನ್ ಚಾನ್ಸಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರ ತಂದೆ ಮನೆಗೆ ಹೋಗ್ತಾರೆ, ಯಾರು ನೋಡ್ಕೊಳ್ಳೋರು ಇಲ್ಲ ಸ್ವಾಮಿ. ಇವ್ರಿಗೂ ಯಾರು ಆಶ್ರಯ ಇಲ್ಲ. ಸಣ್ಣ ಮಗುನ್ ಸ್ಕೂಲ್ ಕಳ್ಸೋದು, ಕರ್ಕೊಂಡ್ ಬರೋದು ಅಷ್ಟೇ ಈ ಅಮ್ಮನು.
ಎಲ್ಲಿದ್ದೀರಾ ನೀವು?
ಈಗ ಅಲ್ಲೇ ಬಂಸಂದ್ರದಲ್ಲಿ ಇರೋದು ಸ್ವಾಮಿ.
ಬಂಸಂದ್ರದಲ್ಲಿ ಇಟ್ಕೊಂಡು ಕೇಸ್ ಹಾಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಬಂಸಂದ್ರ ಆನೇಕಲ್ಲು 15 ಕಿಲೋಮೀಟರ್ ಆಗುತ್ತೆ. ಬಂಸಂದ್ರ ಮಾಲೂರು 25 ಕಿಲೋಮೀಟರ್ ಆಗುತ್ತೆ. ಮೈ ಲರ್ನ್ ಫ್ರೆಂಡ್ ಅವರು ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು, 70 ಕಿಲೋಮೀಟರ್ ಆಗೋದಿಲ್ಲ ಸ್ವಾಮಿ, 25 ಕಿಲೋಮೀಟರ್ ಆಗುತ್ತೆ. ಅವ್ರಿಗೆ ಮಾಲೂರೇ ಅನುಕೂಲ ಇದೆ ಸ್ವಾಮಿ. ಯಾಕೆ ಅಂದ್ರೆ ಮಗುನ್ ನೋಡ್ಕೊಳ್ಳೋರು ಇಲ್ಲ ಅಲ್ಲಿ ಬಂಸಂದ್ರದಲ್ಲಿ. ಇಲ್ಲ ಆದ್ರೆ ಅವ್ರ ತಂದೆ ಮನೇಲಿ ಮಗುನ್ ಬಿಡ್ತಾರೆ, ಕೇಸ್ಗೆ ಹೋಗ್ತಾರೆ, ನೋಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ. ಮಾಲೂರು ಅನುಕೂಲ ಇದೆ. ಅದಕ್ಕೋಸ್ಕರ ಮಾಲೂರಲ್ಲಿ ಈಗ ಆಲ್ರೆಡಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕಮೆಂಟ್ಸ್ ಆಗೋಗಿದೆ. 24ನೇ ತಾರೀಕು ಕನ್ಕ್ಲೂಡ್ ಆಗುತ್ತೆ.
No, that Lord, there is also a 498A petition pending before Anekal court, my lords, filed by the respondent.
DV Act case ಮಾಲೂರಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಕೇಸು.
Then other case is also there in the Malur, Mr.
ಮಾಲೂರಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ.
In Anekal also there is a 498A petition.
498
ಅಲ್ಲಿ ಒಂದಿನ ಎವಿಡೆನ್ಸ್ ಕೊಡೋದಕ್ಕೆ ಹೋಗ್ತಾರೆ, ಅದಕ್ಕೇನು ತೊಂದರೆ ಏನಿಲ್ಲ.
It is a different, because where the police has been registered FIR, there it will be done.
Please.
Now that it is an evidence stage, let it be complete. Yes, that's all.
My lord, if it is to be completed in Malur, my lord, time may be fixed, my lord, 3 months.
Yes, the time limit.
Please, my lord.
Yes. What is the stage now?
ನಾವು ಪ್ರತಿ ಡೇಟ್ ಅಲ್ಲೂ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತಾ ಇದೀವಿ.
Cross of PW1.
ಯಾವ್ದು ಡೇಟ್
Yes, we'll also fix an liability on you that you don't ask any further time.
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಟೈಮ್ ಕೇಳಲಿಲ್ಲ ಸ್ವಾಮಿ ಎಲ್ಲೂ.
ಯಾಕೆಂದ್ರೆ ಮತ್ತೆ ಅವ್ರದ್ದು ಎವಿಡೆನ್ಸ್ ಬಾಕಿ ಇದೆ. She has to travel.
Civil petition is filed by husband seeking transfer of MC number 36 of 2018 pending in the file of Senior Civil Judge JMFC Malur to Senior Civil Judge JMFC at Anekal. Learned counsel for petitioner husband has contended that now that respondent wife is shifted to Anekal.
ಆನೇಕಲ್ಗೂ ಇವ್ರಿರೋ ಅಡ್ರೆಸ್ಗೂ 15 ಕಿಲೋಮೀಟರ್ಸ್ ಡಿಸ್ಟೆನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ. ನಾಟ್ ಆನೇಕಲ್ ಸ್ವಾಮಿ, ಅದು
I shifted to Bamsandra village,
Bamsandra.
Anekal.
ಹೌದು.
If this civil petition is allowed, MC is transferred to JMFC, Senior Civil Judge JMFC Anekal. It will convenient for both husband and wife. Hence he sought for allowing that civil petition. Learned counsel appearing for respondent has contended that, respondent and wife contended that respondent is a permanent resident of Malur.
ಹುಲಿಮಂಗಲ ಹೊಸಕೋಟೆ ವಿಲೇಜ್.
For temporary residence, she is residing in Bamsandra village, Anekal Taluk. He contended that matter is set down for evidence of the party.
ಕ್ರಾಸ್ ಆಫ್ PW1.
Cross of PW1.
ಅದು ಫರ್ದರ್ ಕ್ರಾಸ್ ಸ್ವಾಮಿ, ಆಲ್ಮೋಸ್ಟ್ ಮುಗ್ದಿದೆ.
Yes. Cross of PW1. The respondent will not take any time in the case. The matter can be heard and disposed of in Malur.
One last submission, my lords. One last submission. The child is admitted in a school at Bomsandra, my lords. The child and the mother are staying together.
In any evidence ಇದೆಯಲ್ಲ, I will conclude this.
Please, my lords. ಯಾಕೆಂದ್ರೆ ಮತ್ತೆ ಮಗು ಸ್ಕೂಲ್ಗೆ ಹೋಗಿದೆ, ಸ್ಕೂಲ್ಗೆ ಹೋಗ್ಬೇಕು ಅಂತ ಕಾರಣ ಕೊಟ್ಟ.
I will make that they should not take any further time, Mr.
Please, my lords. Much.
In view of the above civil petition is disposed of. The Senior Civil Judge JMFC Malur, the family court Senior Civil Judge JMFC Malur is directed to dispose of that MC number 36 of 2018 as expeditiously as possible, not later than 6 months from date of receipt of this copy of this order. It is also made clear that respondent wife should not take any time before the trial court has to go on with that matter day-to-day basis.
Please,
With that observation, the civil petition is disposed. Yes.
much of it.
Serial number 6 adjourned. Serial number 7 GJ Sunkapur for petitioner Rajeshwari BR.
I am appearing for the respondent, my lord.
Petition.
As the respondent husband filed a restitution conjugal rights against this petitioner. And today the respondent present, kindly refer the matter for mediation. He is ready to take back the petitioner.
No, that which serial number?
7.
Number 7, my lord.
7. Yes, this is, you are appearing for respondent.
Yes.
Yes, you are ready, we will refer it to that mediation.
Please, my lord.
Yes. Where? Bangalore.
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 Kindly have it on 3/9, Your Honor.
At the request of parties, refer this matter to Karnataka Mediation
Shanivar.
Center at Bangalore. Parties are directed to be present before the Karnataka Mediation Center on 3rd September.
Please.
3rd September
Please.
At 2 o'clock,
at
2 PM.
2:30. Yes. Office is directed to intimate the same to that.
Much obliged.
Interim order kindly.
Interim order granted earlier is extended till next date of hearing.
Much obliged.
Much obliged.
Serial number 8 Venkatesh HN.
This is a petition filed by the wife, my lord, seeking transfer from Bangalore to Mysore family court, my lord. The reason is that she is having 2-year-old twin babies. And the husband who is in Bangalore has filed the petition in MC 2338 of 2024 on the file of 4th additional principal family court judge Bangalore, my lord.
For dissolution of marriage.
She is residing in Mandya.
Has she,
And she is having 2 babies, my lord, female babies.
what is that age? ಏಜ್ ಎಷ್ಟಿದೆ ಮಕ್ಕಳಿಗೆ?
ಸ್ಟೇಜ್ ಇವಾಗ ಇದರಲ್ಲಿ
ಅಲ್ಲ ಮಕ್ಕಳದ ಏಜ್ ಎಷ್ಟಿದೆ?
ಮಕ್ಕಳು 2 years.
ಇಬ್ಬರು 2 years.
ಇಬ್ಬರಿಗೂ ಟ್ವಿನ್ ಬೇಬೀಸ್.
Yes. Then has she filed any case?
She has not filed any case. Only husband has filed the case.
Yes, issue notice.
It is the emergent notice. Maybe.
Issue emergent notice.
Serial number 9 Sandhya D for petitioner.
Yes, pass out.
Serial number 10 FS Dabali for appellant. Connected matter Shripadvi Shastri.
My lord, I am for appellant, my lord. My lord, totally these 4 cases, my lord. Out of that, I am appearing in 5193 of 17 preferred by the claimant and 3868/17 by the KSRTC. My lord, what happened is, my lord, in HR Renuka's case, my lord, 2798 of 18.
Non-compliance of office objection.
My lord, it is
Based
not
on the
necessary, it seems,
PF
because that respondent is served in.
ಶಾಸ್ತ್ರಿಗಳೇ ನಾನು ಹೇಳ್ತೀನಿ ರೀ ಮೆಲಾಡ್ ಇನ್ ಮೈ ಕೇಸ್ ಮೆಲಾಡ್ 2798 ಮೆಲಾಡ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಮೆಲಾಡ್ is already served in serial number 10 and 10.1 ಮೆಲಾಡ್. He is the owner of the lorry.
Yes.
So that since they are served unrepresented ಮೆಲಾಡ್ the
It
same
will be dismissed.
yes the same could be ಮೆಲಾಡ್
Learned counsel appearing for the appellant through VC submits that notice to that respondent number 3 in 10.3L may be dispensed. Submission of learned counsel for the appellant is taken on record. Notice to respondent number 3 is dispensed.
ಮೆಲಾಡ್ in view of the fact that ಮೆಲಾಡ್ ಯಾಕೆಂದ್ರೆ ನಾಳೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯವರು ಬೇರೆಯವರು ಇದನ್ನ ತಗೋಬಾರ್ದು 10 and 10.1 ನಲ್ಲಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಆಗಿದೆ ಅಂತ.
I submitted that since the respondent number 3 has been served in the connected matter.
Yes.
Not represented by any counsel. Hence he sought for dispensation of notice. Submission is taken on record. Notice to R3 is dispensed. Yes, madam.
ಮೆಲಾಡ್ ನನ್ನ ಕೇಸಲ್ಲಿ ಇಷ್ಟೇ ಇರುತ್ತೆ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಕೇಸ್ ನಲ್ಲಿ
ಎಲ್ಲ ರೆಡಿ ಇದ್ದೀರಾ?
ನಂದ್ರಲ್ಲಿ ಒಂದೇ ಪಾಯಿಂಟ್ ಇರುತ್ತೆ ಸ್ವಾಮಿ. ನಂದ್ರಲ್ಲಿ ಏನು ಅಂದ್ರೆ ನನ್ನ MBC ನಲ್ಲಿ ನಮ್ಮ ಲಾರಿ ಡ್ರೈವರ್ ಮೇಲೆ 50% ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಮೇಲ್ಗಡೆ 10 and 10 ನಲ್ಲಿ ಇದು 10 and 10.1 ನಲ್ಲಿ 75% on the bus, 75% on the bus and 25% on the lorry.
The FS Dapali has to argue.
Yes, madam. Yes.
Where is he?
My lord, in
ಅಲ್ಲ ನಮ್
In
ಕೇಸಲ್ಲಿ
my
50-50
appeal-
ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ 737
I think all council has to be present. I can't hear part by part.
Please.
Pass over.
Dabali ಅವ್ರು ಇರ್ಬೇಕು sir.
Yes, pass over.
Serial number 11, BM Siddhappa for appellant.
Second is ready,
Ravish
please.
Pitni.
65 days delay is controlled. Yes, Mr.
ಫೈಲ್ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ. ಟೈಮ್ ಬೇಕು ರೆಕಾರ್ಡ್ಸ್
Pass over.
TCR ಇದೆ ಎಲ್ಲ ಇದೆ ಸ್ವಾಮಿ, ನಾನು ಅಸಿಸ್ಟ್ ಮಾಡ್ತೀನಿ. Not a case for
Let us
enhancement.
see. Hold on. Yes.
Pass over. I can give the papers to you.
Pass over.
ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಅದಕ್ಕೆ
ಅವ್ರು ಕೊಡ್ತಾರಂತ್ರಿ. ಅವ್ರು you will assist. Let us see. Yes. Pass over.
Serial number 12, Nagaraja Hegde for appellant.
Second respondent, ready,
Pitni.
please, ma'am.
Yes, Nagaraj Hegde. Pass over.
Pass over.
Serial number 13, R Shashidhara for appellant, PB Raju.
Yes. There is.
ಇದು
Pass over.
please.
Serial number 14, Arjun. Serial number 15, Arjun. Serial number 16, Gopal Krishna N for appellant. Connected matter, B Latif.
Kindly pass over this matter, my lord. Liability, please, my lord.
R1 ಗೆ avoid.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇಲ್ಲ ಅದರಲ್ಲಿ ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಫರ್
Yes. Pass over.
Serial number 17, Vivekananda TP for appellant, CR Ravi Shankar.
Yes, Mr. What is that? Only enhancement or
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಸರ್.
where is Ravi Shankar? Pass over once. Yes, pass over.
Serial number 18, Rangegowda NR for appellant, SB Egdem Mulkund, connected matter.
Where is that Hegde? Pass over.
I appear for the appellant, my lord.
Ready, Mr. Hegde?
Yes, my lord, I am ready.
Where is that Rangegowda? It is a case of death.
My lord, it's a case of death of a infant aged about 3 years. My lord, the tribunal has granted a sum of rupees 2,65,000. Their enhancement is for 5 lakhs, my lord. That I am not regarding a Kishan Gopal case. But in this case, my lord, the vehicle involved in the accident is a bus, my lord. Other day it was argued, and in this, my lord, the bus as on the date of the accident had no permit as on the date of the accident. And the tribunal relied on some temporary permit, etc. given. My lord, the record disclosed as on the date of the accident, there was no permit. And subsequently, it when my lord, the proceeding shows. My lord, am I audible, my lord? Am I audible, my lord? Am I audible, my lord? ಕೇಳ್ತಾನೆ ಇಲ್ಲ. My lord, am I audible? ಏನಾಗಿದೆ ನಂದೊಳಗಲ್ಲ ಹೋಗೋದು. My lord, am I audible? ಇಲ್ಲೇ ಇದ್ರು ನೋಡಿದೆ. My lord, am I audible? Ender set I am going, my lord. ಈಗ ಇಲ್ಲೇ ಇದ್ದಿಲ್ಲ. 054. Am I audible, my lord? Yes, am I audible? Hello.
Now you can hear Mr.
Yes, my lord. My lord, our contention was, my lord. Sorry, my lord. Sorry, my lord. The other side, my lord, it happened. So, my lord, our contention was, my lord, this accident took place. My lord, your lord, lords may exhibit from R5 onwards. Your lords may kindly see the
a permit copy produced, my lord. And this permit was issued from 19, my lord, the accident took place, my lord, on
2017.
yes, my lord, 30/11/2017. Yes, my lord. 30/11/2017, my lord.
Yes.
And this permit was, my lord, expired, my lord. First permit was, my lord, this permit was issued for the period from, my lord, 29/10 it expired, my lord. 29/10/2015 expired. Then
Where is that?
subsequently, my lord, that is first permit, my lord. Permit was expired on 29/10/2015.
Where
Then-
will you get?
Exhibit
My
R2.
lord, Exhibit R2, my lord. R2, my lord.
R2.
Yes, my lord.
Yes.
And subsequently, my lord, this permit accident took place. I submitted that as on the date of the accident, our contention,
10 to
that there was,
2015.
yes, my lord. After the 29/10/2015, it was expired. Subsequently, my lord, as on the date of the accident, this permit was not there. From then, my lord, they say that they made an application before the proper authority. Then your lords may kindly see the proceedings of the authority. Temporary permit from exhibit R5, my lord. Your lords may kindly find it from R5. R5 say, my lord, this, if we look into the proceedings of the RTA, from, my lord, on their application, my lord, this concerned authority has renewed the permit for the period from 19/2017 to 39/2017, the first instance, and second instance, my lord, this 14/2018 to 31/5/2018. Then, the document produce ಮಾಡಿದ್ರೊಳಗೆ ಇದೆ. And then ultimately, my lord, if we look into the
Exhibit R5 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
R5 ದಲ್ಲಿ, my lord, you lot may kindly appreciate. R5 ದಲ್ಲಿ R5 say this 16/2019
Temporary permit.
Temporary permit, my lord. 16/2019 to 39/2019 ಗೆ issue ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು.
So that's why, but as on the date of the accident, that, my lord, 30/11/2017, there was no permit at all.
Yes.
The
Yes, Mr.
tribunal,
My lord,
Where is the permit on 2017?
2007, my lord, exhibit R5 is the certified copy of the temporary permit issued to the vehicle on 29/10/2000. Renewal ಗೆ application ಹಾಕಿರೋದು 29/10/2015 ಅಲ್ಲಿ. 29/10/2015 ಅಲ್ಲಿ, my lord.
2015.
Please.
ಎಲ್ಲಿದೆ?
Exhibit R8 ಅಲ್ಲಿ. 2000 rupees renewal requisite fee ಬೇರೆ 6 ಅಲ್ಲಿ. Requisite fee for renewal 16/8 ಅಲ್ಲೇನೆ ಪೇ ಮಾಡಿದೀವಿ, ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ. Exhibit R8 ಅಲ್ಲಿ ರಸೀಟ್ ಇದೆ.
ಆಯ್ತು, ಮತ್ತೆ ಅವತ್ ಡೇಟ್ ಇಂದ ಕೊಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ. ವೇರ್ ಇಸ್ ದಟ್?
ಅದಿದೆ, ಇದು KT ನಲ್ಲಿ ಆರ್ಡರ್ ಇತ್ತು ಅಂತ ಅಪೀಲ್ ನಂಬರ್ 35 of 2018, 31/1/2018 ಅಲ್ಲಿ KT ನಲ್ಲಿ there was an order, my lord. Exhibit R5 may kindly be seen.
R5 ಅಲ್ಲಿ ಈಗ ನೀವು ಅಪ್ಲಿಕೇಶನ್ 2015 ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ ರಿನ್ಯೂವಲ್ ಡೇಟ್ ಫ್ರಮ್ ದಟ್ ಡೇಟ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ, ಬಟ್ ರಿನ್ಯೂವಲ್ ಇಸ್ 2019. ಮತ್ತೆ ವೇರ್ ಇಸ್ ದಟ್ ಪರ್ಮಿಟ್ ಡ್ಯೂರಿಂಗ್ ದ ಪೀರಿಯಡ್ ಆಫ್
division bench of this honorable court, my lord, renewal of permit, my lord, it covers, my lord, from the date of
see, if you are filed an application within the time,
please,
if it is renewed after 3 years, renewal certificate ಅಲ್ಲಿ ಅವತ್ತಿನ ಡೇಟ್ ಇಂದ ತೋರಿಸ್ತಾರೆ. That is not shown. That means to say from 2019 there is no this thing.
Otherwise, my lord, pay and recovery may be ordered.
Where is that? What is this?
My lord, 2,65,000 has been awarded. And, my lord, this
ಇದ್ರಲ್ಲಿ ಏನಿದೆ? Renewal permit application should be filed not less than 15 days before the date of expiry of the permit. Clearly state that if the application can't be made within 15 days before the expiry. State Transport Authority can still entertain that application renewal of the permit if it is satisfied that application was prevented. If the permit is renewed upon the application made before expiry, automatically renewal takes place from the date of expiry.
Please.
ಇದ್ರಲ್ಲಿ ಆ ತರ ಮಾಡಿಲ್ಲಲ್ಲ. Whenever renewal is sought after the expiry of the time, if the concerned authority entertain that application sections of grant renewal by condoning the delay, obviously renewal goes back to the date of the expiry. Provision of 81 of Motor Vehicles Act. ಅವಾಗ ಅವತ್ತಿನ ಡೇಟ್ ಇಂದ ಹಾಕ್ಬೇಕು.
Next week ಮಾಡ್ತೀನಿ ಹೇಳು.
Here it is not there.
Next week ಹೇಳಿ.
What is the tribunal held, Mr.?
Tribunal refers to my lord the document.
Para 29
Para 29.
Please.
ಏನ್ ಹೇಳ್ತಾರೆ?
By perusing exhibit R6, it appears that respondent number 1 had a requisite fee for renewal of the permit 16/8/2015 itself. Exhibit R8 contains the copy of the application submitted by the respondent number 1 for renewal of his permit. Exhibit R9 is the copy of the gazette notification, wherein it is stated that existing permits with the trips and vehicles to whom permits are granted to issued transport authorities in operation as on 18/12/2014 and also pending renewal to operate their services on the interstate, intrastate, interdistrict and intra-district routes, notwithstanding anything contained in any of the approved schemes. The existing permits in operation with trips and vehicles of the private stage carriage operators who are operating on non-monopoly routes are as on 24/3/2008. The existing permits are in operation according to the notification number so and so dated 28/9/2017 issued by the government.
Since that matter is pending before the High Court, Mr. Hegde.
Yes, my lord.
There is a notification issued by the government. Whatever that permit is issued, it has to be continued.
But my humble submission is, my lord, the owner appeared before the tribunal and contested the matter, but he had not entered into the witness box. He could have entered the witness box.
No, see, no, here, admittedly, that license earlier,
Earlier, my lord,
2015
ವರೆಗೂ ಇತ್ತು.
2015 ವರೆಗಿತ್ತು.
ಹೌದು.
From, if there is any applications are registered that registration is existing on 18/12/2014.
Yes, that is there, my lord.
That has been understood that continued by notification issued on 2017.
But my humble submission is, my lord,
there is a case pending before that High Court.
Yes, madam.
Therefore, that presumption is that permit has been continued, Mr. Since
My
he has
humble
also filed an application for renewal.
Please.
My humble submission is, my lord, this we have examined the concerned RTO, the official of the RTO, my lord, and he gave an evidence stating that, my lord, he referring to all these documents. He says, my lord, as on the date of the accident, there was no permit as such in respect of that vehicle. So in such circumstances,
what to say about this judgment of the High Court and that notification?
that, my lord, the matter was remanded to consider afresh the case of all the transport operators afresh. Then what has happened, my lord, we do not know later.
No, this, see, I think I have been that another matter also we have been examined in view of that pendency of the case before the High Court. Then government has issued a notification because they can't renew that any permit. The permit which has been existing in 2014 has to be continued as a permit.
Paragraph 31 only, detailed discussion, my lord.
Yes.
But otherwise, my lord, may I make one submission, my lord? As
Yes.
far as the petitioner is concerned, my lord, he is a third party, my lord, he is necessarily to be paid. But in respect of owner, my lord, your lords may kindly remand the matter, so we will lead the evidence.
No, it is already that there is a government notification. That cannot be.
Then I will leave it to your lordship.
Yes, yes, I will consider your argument.
Yes,
my lord.
What is that 31?
31, my lord, from the document produced by the RW1 and from its oral evidence, it is proved that the permit issued to the respondent number 1, though expired on 29/10/2015, a temporary permit was given subsequently. From the contents of the judgment rendered by the Transport Tribunal as per the government notification, it can be gathered that the public carriage permit issued to private stage carriage are inoperative in view of notification issued by Government of Karnataka. Therefore, it can be gathered that the vehicle of the respondent number 1 had a permit as on the date of accident.
Yes. What is that this thing?
My lord, the announcement, my lord, the death of 10 years old boy claimed by my lord, mother and father and mother. My lord, the trial court awarded 2,65,000. Lord, in view of the Kishan Gopal case, my lord, 5 lakh.
What is the age of that
10 years old boy.
ಟ್ರಿಬ್ಯುನಲ್ ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ?
Tribunal, my lord, 35 ಅಲ್ಲಿ. Salman was aged only 10 years old at the time of his death. Loss of love and affection 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Funeral obsequies, my lord, 15,000. Others ಅಂತನ only 2 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕಿಶನ್ ಗೋಪಾಲ್ ಅಲ್ಲೇ ಆನ್ಯುವಲ್ಲಿ 30,000 ತಗೊಂಡಿದ್ದಾರ.
Please.
All rupees value was taken as 30, applying that multiplier 15, 4.5 lakhs, adding 50,000 towards the loss of love and affection. Yes. Yes, Mr. Hegde.
Yes, my lord. Regarding quantum, my lord, I think, my
Yes.
lord, that judgment is correct. My lord.
Yes, ತಗೊಳ್ಳಿ. Serial number ಎಷ್ಟಿದು?
18, my lord, 18.
Shri S.V. Hegde, Learned Counsel, appearing for insurance company has contended that the offending vehicle has a permit, route permit,
Please.
Permit, my lord, passenger
Permit,
carrying
permit.
vehicle. Passenger
Yes.
carrying vehicle, my lord.
Yes, permit. ಯಾವತ್ತು ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು?
Date of accident, my lord,
30/11/2017.
ಇದು ಎಲ್ಲಿವರೆಗೂ ಇತ್ತು?
This, my lord, this was valid from 30/10 to, for the period from 30/10/2010 to 29/10/2015.
15 orgo.
15
Has
ವರೆಗೆ.
contended that permit in respect of
Bus
offending
bearing number.
was valid from 30/10/2010 to 29/10/2015. It was renewed in the year 2019. As on the date of the accident, that is on 30/11/2017, there was no permit to that vehicle. Since insured has violated that policy condition, the insurance company is not liable to pay any compensation. The tribunal has error in fastening the liability on that insurance company. Secondly, he has contended that considering that age of the deceased, the compensation awarded by the tribunal 2,65,000 is on higher side. Hence, he sought for allowing that appeal filed by insurance company. Shri Rangegowda, Learned Counsel, appearing for the claimant, has contended that the offending vehicle license permit was existing still 29/10/2015. ಯಾವಾಗ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು?
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ my lord 29/10/2015 ಅಲ್ಲಿ ರಿನ್ಯೂವಲ್. 29/10/2015
ಅವತ್ತೇ.
ಅವತ್ತು.
On 29/10/2015 itself, the owner of the offending vehicle has filed an application for renewal of the license. Since in respect of issuance of permit, there is a matter which was pending before the tribunal before the High Court, before the High Court of Karnataka, the government has issued a notification on 28/9/2017 that the permit issued to that vehicle, which was existing as on 18/12/2014, has been temporarily continued till that dispute has to be resolved in that High Court. Immediately after, the license has been heard the learned counsel for the parties. Thereos, judgment and award and original records. It is not in dispute. Master Salman died in road traffic accident occurred on 30/11/2017 due to rash and negligent driving of driver of bus bearing registration number KA16 A4161. The offending vehicle has a permit valid from 30/10/2010 to 29/10/2015. The owner of the offending vehicle has filed an application on 29/10/2015 for renewal of the permit, license permit, which was pending before Transport Authority for consideration. The accident was occurred on 30/11/2017. In respect of issuance of permit in respect of the vehicle is concerned, the case was pending before High Court of Karnataka. Therefore, government has issued a notification on 28/9/2017, subject to decision of the case pending as 18/12/2014 in the year 2019. Considering this aspect of the matter, it is not in dispute. As on the date of the accident, the master Salman was aged about 10 years. In similar circumstances, the apex court in case of Kishan Gopal Supra has considered annual income of the deceased as 30,000, applying 15 multiplier and adding 50,000 rupees towards love and affection. Accordingly, the compensation awarded by the tribunal has been modified. Loss of dependency has been awarded 4,50,000 and 50,000 towards love and affection. Totally 5 lakhs has been awarded with 6% interest. Accordingly, the appeal filed by the claimant is allowed in part. The appeal filed by that insurance company is dismissed. Yes.
Amount in
But-
deposit.
Amount in deposit is transferred. Yes.
My lord, in their case, my lord, I may be permitted to file wakalat.
Yes. SV Hegde is permitted to file wakalat within 3 weeks from today.
Problem.
R4 ಯಾರು ಮಿಸ್ಟರ್ ಹೆಗ್ಡೆ ನಿಮ್ ಕೇಸಲ್ಲಿ
Owner of the vehicle.
notice to R4 is
Affected matter
dispensed.
non-material service ಆಗಿದೆ.
Yes. Notice to R4 is dispensed.
Office objection matter, first time, serial number 19 adjourn, serial number 20 Manohar N for petitioner,
Yes.
serial number 20 Manohar N,
Password.
serial number 21 adjourn for order, serial number 22 Vishwanatha N for petitioner, Joseph Anil Kumar A.
Petitioner.
Yes, Mr. Maintainability of the civil petition, non-compliance of office objection.
1 week time may be granted even.
Why maintainability has been raised?
See, there are two simultaneous petitions were filed before the civil court. Having the same content. We have make an application.
Transfer of OS pending in the civil judge with existing petition pending on the small cost search to hear along with that OS on the. No, that cannot be. Yes. Last occasion you have submitted. Yes, at the request of counsel for the petitioner. Leave this matter of 2 weeks.
Serial, serial number 23 R Shashi Kumar.
Memo of withdrawal is filed, my lord. Matter has been settled between the parties.
Yes, learned counsel for the petitioner has filed a memo. So containing that the parties have settled on a matter out of court, out of court. Hence is sought for withdrawing that writ petition has not pressed. Memo dated 14/8/2024 is taken on record. The above petition is dismissed as not pressed.
Serial number 24 Vijayendra D Joshi for petitioner, VR Prasanna.
I am appealing
Make us give-
I am appealing.
For the petitioner, my lord. My lord, the petitioner has traveled out of town on an
You are
emergency
appearing
work.
for?
For the petitioner, my lord.
You are appearing.
I am appealing for Prasanna VR, amicus curiae appointed.
You come this side. That is the confusion. Yes. Yes, madam.
Appearing for the petitioner, my lord. My lord, my senior advocate has traveled out of town. He'll be returning on 28th.
What
He's
is
out
that
on emergency work.
maintainability objection?
Request you to grant some time for a week or two, my lord, please.
The CP is meant to be filed under. No, this matter. Prasanna, you have been appointed.
appealing for
Yes, my lord.
Where is that? He wants that you have to verify. Where is he? Whether he has to go before the board or not, that he wants to verify.
My lord, sir, my senior is not in station, my lord. So he has been-
Yes, at the request of parties. Please this matter after 2 weeks.
Serial number 25 Suresh M Lathur for appellant, ICICI Lombard.
For appellant in this case,
Hmm.
madam. R1, we have filed a dispensation of R1, madam. Memo for.
Notice to R1 is dispensed at the risk of the appellant. ICICI is there.
ICICI Lombard.
You are there, Mr. Vijay Kumar.
No, my lord. Rushmendraya. Rushmendraya.
I'll take my.
You are Raju.
PS Jagdish.
Yes, Jagdish is directed to take notice for. Respondent is served unrepresented. Jagdish is directed to take notice for.
PS Jagdish.
PS Jagdish is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. Sorry, copy kodi. Notice to R1 is dispensed at the risk of the appellant.
Serial number 26, Chetan B for appellant, K. Suresh.
Appellant, not sure. I appear for respondent number 2, my lord.
Yes.
I am ready, my lord.
Notice to R1 is dispensed.
Please.
Yes. Yes, Mr. Chetan.
Date of accident is, my lordship, 14/7/2017, my lordship.
Yes.
Age of the appellant is, my lordship, time of accident is 32 years, my lordship. 12 days in inpatient, my lordship. Is working as a driver, income of 20,000 per month, my lordship.
Yes, tribunal.
Tribunal has taken 8,000 per month, my lordship, and disability assessed by the doctor, my lordship, 20% to the whole body, my lordship. The tribunal was taken 11%, my lordship.
Discussion.
Para number, my lordship, 19, my lordship.
Yes,
Page
read.
number 18, my lordship.
Read.
Petitioner has adduced the evidence of Dr. Ramesh B, orthopedic surgeon at Victoria Hospital, Bengaluru, who has filed his affidavit in lieu of chief examination, got marked as Exhibit P12, OPD book and Exhibit P3, X-ray PW2 in his affidavit said that he was not the treated doctor and is in road traffic accident. Petitioner has suffered comminuted fracture, distal third tibia and fibula right and fracture of left lateral condyle humerus, and he has underwent internal fixation of tibia and fibula, and humerus fracture is treated conveniently. Because of that, petitioner suffered disability in respect of range of movements, difficult to squatting, climbing upstairs, difficult to stand for long time, difficult to lift weight with lift upper limb, and difficult to routine activities. And he is also having disability to walk with limb tenderness over right ankle, restriction of joints, movements of right ankle, left elbow, flexion, extension, difficult to squat and floor, climbing upstairs, walk on slope, stand on limb, and difficulty over the head with right lower limb. And he suffers whole body disability to extent of 50% and 14% for left upper limb. And he suffer whole body disability to extent of 5%, in total 20% disability to the whole body. In this, the tribunal has taken 11%.
Yav extent of 15%, 14% of left upper limb antandre?
My lordship, in evidence of the doctor, my lordship.
5% in total, 5% total.
Doctor evidence I am the opinion that he suffers from permanent physical disability of 30% of right lower limb, which is 50% whole body.
I am the opinion that permanent physical disability of 30% of right upper limb, 15% whole body young bharat 30%. Then
and 14% to the 5% and total like 20% and
5% to that whole body.
Total 20% and
11% ತಗೊಂಡ್ರೆ ಸರಿಯಾಗಿದೆ ಸ್ವಾಮಿ.
Yes.
ಅಲ್ಲ ಟೋಟಲ್ ಆಗಿ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಟೋಟಲ್ ಮಾಡಿದ್ರು ಅಲ್ಲಿ 44% ಬರುತ್ತೆ ಸ್ವಾಮಿ. ಅದನ್ನ ಎರಡನ್ನು ಇದು ಮಾಡಿ ಟೋಟಲ್ ಮಾಡಿದ್ರು
15% ಬರುತ್ತೆ ಅಷ್ಟೇ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
Yes.
The income of the tribunal has taken 8,000 per month, my lordship.
Yes.
ಆಮೇಲೆ loss of income during laid up period ಕೊಟ್ಟಿಲ್ಲ my lordship. ಆಮೇಲೆ loss of amenities 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದನ್ನ inpatient in
medicine transportation ಕೊಟ್ಟಿದ್ದಾರೆ. Nourishing and food and ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of earning which injured would have been made, he has been injured comprising loss of earning during the period of treatment. ಎಷ್ಟು ದಿನ ಇದ್ರಿ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ?
12 days.
12 days.
Please.
Yes. Loss of future earning ಆಯ್ತು. Future medical expenses.
Amenities 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. During laid up period ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
Pain and suffering ಕೊಟ್ಟಿದ್ದಾರೆ.
50,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes.
Loss of income during laid up period ಕೊಡಬೇಕು ಮತ್ತೆ amenities ಜಾಸ್ತಿ ಆಗಬೇಕು ಸ್ವಾಮಿ.
Plus 9%.
Please.
Yes, Mr. Suresh.
ಅದ್ರಲ್ಲಿ ಸ್ವಾಮಿ ಇದು ಡಿಸೇಬಿಲಿಟಿ 11% ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ತಗೊಂಡು ಸರಿ ಇದೆ ಸ್ವಾಮಿ, ಬಿಕಾಸ್ ಇಟ್ಸ್ ಫಾರ್ ದಿ ಅಪ್ಪರ್ ಲಿಂಬ್ ಅಂತ ಹೇಳಿರೋದು 11% ಸರಿ ಇದೆ. ಆಮೇಲೆ 9% ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ದಟ್ ಈಸ್ ನಾಟ್ ಕರೆಕ್ಟ್, ಬಿಕಾಸ್ ಇವನ್ ನಮ್ ಬೆಂಚ್ ಡಿಸಿಷನ್ ಇದೆ, ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಡಿಸಿಷನ್ ಇದೆ, Yellano 6%. Therefore, the interest should be awarded at 6% throughout, my lord. Even for the amount granted by the tribunal also 6% ತಗೋಬೇಕು ಸ್ವಾಮಿ. ಆಮೇಲೆ ಇದು 8,000 ತಗೊಂಡಿದ್ದಾರೆ, ಅದು that is to be enhanced. Income should be enhanced because the accident is of the year 2017. Swami. That's all. There is some technical problem, it seems. Court's voice is not audible, my lord.
Sir, Mr.
Yes, my lord.
Yes.
Court's voice was not audible for some time. Now it's all right.
Yes.
Yes, my lord. 11% disability has to be taken, my lord. What the tribunal has considered is proper.
Yes.
And throughout, the interest has to be granted at 6% per annum, my lord. Because the benefits are there. Tribunal has committed an error in granting 9% interest per annum, my lord.
Yes.
The 15% are considered also.
Don't so learned counsel appearing for the claimant has contended that due to that accident, claimant has suffered grievous injury. Doctor has been examined as PW2. In his evidence, he has opined that the claimant has suffered permanent physical disability of 30% to right lower limb, which is 15% to whole body, and 14% to upper limb, 5% to whole body. Totally, he has assessed 20% to that whole body disability. Tribunal has considered whole body disability 11% is on lower side. He further contended that at the time of the accident, claimant was earning 20,000 per month. Tribunal has assessed notional income of the claimant as 8,000 per month is on lower side. Lastly, he has contended that due to that accident, claimant has suffered grievous injury, was inpatient for a period of 12 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering,
50,000.
loss of amenities, other incidental expenses. Compensation. Is as 8,000 per month. Lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for pay interest awarded by the tribunal 9% of the petition and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on to that accident, claimant has suffered the following injury. Doctor has been examined as PW2. In his evidence, he has deposed that the claimant has suffered permanent physical disability of 30% of right lower limb, and whole body is 15%, and 14% disability to left upper limb, and 5% to that whole body. Total, he has assessed 20% to that whole body. Considering that evidence of the doctor, injury suffered by the claimant, and considering that age and avocation of the claimant, I am of the opinion that whole body disabilities can be assessed.
Court's voice is not audible, my lord. There is some error in the video, my lord.
From 10,000 to 25,000.
3 months and 33,000 like 11,000.
Loss of income during the later period has to be granted for 2 months. The enhanced compensation amount carries 6% interest.
Even the amount granted by the tribunals also be restricted to 6%.
That I cannot, Mr. Only enhanced. Yes, Dina. Yes, 56 day delays control.
My lord, in serial number 27, my lord.
Yes.
My lord, R1 is the Oriental, not claimed up bandide. R2 is the owner of the vehicle, unclaimed up. Both.
ಒಂದೇ ಕೊಟ್ಟಲ್ಲ ಎಲ್ಲ ಕೊಟ್ಟಲ್ಲ ಆಗ್ತಿದೆ ಅರ್ಧ ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಹೌದು ರಿಪೀಟೆಡ್ಲಿ ಟುಡೇ ಓನ್ಲಿ there is a
ಎಲ್ರಿ ಇದು ಎಲ್ಲ ಕೊಟ್ಟಲ್ಲ ಇಲ್ಲ ಅಂತಲ್ಲ ನಮ್ದ್ರಲ್ಲಿ ಮಾತ್ರ ಅಂತ yes
serial number 27 Shripad V Shastri for appellant.
R1 is the insurance company unclaimed.
Oriental Insurance Company ಯಾರಿದ್ದೀರಾ? Oriental Insurance Company. Who is that regular counsel?
Hegde Mulkot.
You are there, Mr. Raju.
Yes, I will serve the copy, Mal.
Yes. Raju is directed to take notice. PB Raju is directed to take notice for respondent one other.
Or R1.
Respondent number 1.
R2 Malad unclaimed.
Notice issued to that respondent number 2, written with postal chara unclaimed. In service of notice to R2 is held sufficient. You serve a copy to Raju, Mr.
Yes,
PB
yes,
Raju.
yes.
Yes.
Date, Malad. Old
Next
matter.
week. Next week.
Next week, Malad, I will be out of station. First week of September, Malad.
Yes, reach this matter in first week of September.
Serial number 28 Sanat Kumar KM for appellant.
File a memo for dispensation notice to R1.
Reliance are
P. Pradeep may be direct.
I will take notice, Malad. I will take notice.
P. Vijay Kumar, respondent number 2 is served unrepresented. D. Vijay Kumar is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. Notice issued to the respondent number 1, written with postal chara unclaimed. In service of notice to R1 is held sufficient. Are you going to copy code?
Next week, Malad. Any subject?
Yes, next week.
Please.
Serial number 29, Mohammed Sharif for appellant, IFCO
Appear for
Tokyo.
appellant in this case, my lords.
You are there, Mr. Jagdish, if got okay.
My lord, I think it's a
Not
connected
dispensation.
matter. Next matter is the connected matter.
Oh,
IFCO general.
connected ada.
Connected ಇದೆ.
Is it, next matter is connected, madam?
No, no, ma'am.
Different, yes.
It's different.
If got
Then I will take notice, madam. I will take notice.
R1 is third unrepresented. Jagdish, what is your initial?
PS Jagdish.
PS Jagdish is directed to take notice. What about R2 is unclaimed, notice issued.
My
to
lords,
that
I am filing memo for dispensation of notice to R2, my lords.
Not necessary. R2 postal shara, written with postal shara unclaimed. In service of notice to R2 is held sufficient. Yes.
Serial number
A copy to Jagdish.
Yes, my lords.
Yes.
Serial number 30, Mohammed Sharif.
I appear for the appellant in this case.
I appear for the respondent.
Ready, Mr. Ranab?
Ready, my lord.
Yes, madam.
My
Ready.
lords, next week, one date may be given, my lords, because in this case, my claim is with regard to the future surgery. Though the doctor has told 2 lakh is the future medical expenses, only 15,000 has been awarded. Under that heading, I have to find out whether she has undergone any future surgery, my lords.
Yes.
For that reason, next week, any date may be given.
Yes, at the request, memo filed for dispensation of notice to R2. Notice to R2 is dispensed. Read this matter next week.
A date may be fixed, my lords.
Serial number 31, AS Girish for appellant, O Mahesh.
Appellant lordship,
Hmm.
the postal share has not claimed, it may be
Yes,
held sufficient.
notice issued to that R1 is written with postal shara, not claimed.
One more
In
submission.
service of notice to R1 is held sufficient.
This is connected with MFA 8846 of 2018.
Yes, call
And-
this matter along with that zones.
Serial number 32, Prakash MH for appellant, VC Sitaram Rao.
Lordship, I appear on behalf of the appellant. Lordship, in this case,
Refused.
please, Your Lordship.
Notice issued to that respondent number 2, written with postal shara, refused. In service of notice to R2 is held sufficient. Yes, ready?
Please, Your Lordship.
Ready, Mr. Anup?
My lords, collect judgment from the other side, my lords. Online upload agilla. ಹಾಗಾಗಿ collect a
Next
copy,
week.
my lords. Tomorrow.
Next
Tomorrow
week.
I'll do it.
Yes,
Right.
this matter next week.
Please, a date may be fixed, Your Lordship.
Bharat next,
Serial number
Monday or
30.
Tuesday.
Oblige, Your Lordship.
Shivakumar P for appellant, Lakshmi Narayana C.
And for respondent, my lord, matter may be disposal, my lord.
Yes,
Pass
where
over,
is
my lord.
Shivkumar, pass over,
Kumar is another quotal, my lord.
pass over.
Serial number 34, Rajaram S for appellant.
I am filing dispensation memo for R1, my lord.
You will take notice, Mr. Kumar.
Please, madam.
Bini is directed to take notice for respondent number 2. The net counsel for the appellant has filed a memo. Dispensation of notice to R1. Memo is taken on record. Notice to R1 is dispensed. You serve a copy to him.
Much obliged.
Yes. Bini is directed to take notice and fill it.
Serial number 35, P Pradeep for appellant, NR Rangegowda.
And for appellant, my lord, first week's time, my lord, to take steps, my lord.
Week's time is granted to do the needful.
Serial number 36, Averi SS for appellant,
And for respondent.
VC Shivanegowda.
Appear for the apparent This is a case of death, my lord. The case has been dismissed before the trial court.
Served.
Copy today served, my lords.
ನೀವು ಶಿವನಗೌಡಗ
VC Shivanegowda representing behalf of VC.
ಇದೇನಿದು accepting of court notice R3 since Shara served. R3 is Shivanegowda, yes. IA2 for condonation, we will condone the delay 54
Please, my
days.
lord, delay may be condoned.
There is a delay of 54 days in filing an appeal. IA1 of 20 is filed for condonation of delay. Peruse that affidavit. For the reason stated in that accompanying affidavit, delay of 54 days in filing an appeal is condoned.
Meanwhile, call for TC, my lord. Claim petition has been dismissed, my lord.
Petition dismiss ಆಗಿದೆ. Another case ಅಲ್ಲಿ allow ಆಗಿದೆ, settle ಆಗಿದೆ ಲೋಕ ಅದಾಲತ್ನಲ್ಲಿ.
ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್?
No driving license, no valid DL ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
ನಾಟ್ ವ್ಯಾಲಿಡ್, ಅದರಲ್ಲಿ ದುಡ್ಡು ಕಟ್ಟಿದ್ದಾರೆ, ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ, ಜಾಯಿಂಟ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಮತ್ತೆ ಇನ್ನೊಂದ್ ಕೇಸಲ್ಲಿ ಏನು ಇಬ್ರು ಇದ್ರಾ?
ಅದರಲ್ಲಿ
How that accident occurred, mister?
he was initially fell on the cycle and sustained injuries. Later he was on the shifted to, he was, since the
ಆಯ್ತ್ರಿ,
injuries Manipal hospital shift ಮಾಡುವಾಗ ದಾರಿಲಿ ambulance met with an accident. In that process, before reaching the hospital, he passed away.
ಆಯ್ತ್ರಿ, ಇನ್ನೊಂದೇನು? ಇನ್ನೊಬ್ರು ಯಾರು?
Injuries.
ಇಬ್ರು ಹೋಗ್ತಿದ್ರ ಸೈಕಲ್ ಅಲ್ಲಿ?
ಆಂಬ್ಯುಲೆನ್ಸ್ ಅಲ್ಲಿ, ಆಂಬ್ಯುಲೆನ್ಸ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ರು ಅಂತ ಕರ್ಕೊಂಡು.
No, how that accident was occurred? Deceased Swami was employed wife deceased so and so. He was downstrained some injuries. That's Swami was admitted to the hospital. Said to take Swami came as for medical for better treatment. As such, the petitioner has heard the ambulance. And respondent was ಎಲ್ರಿ ಇಬ್ರಿಗೆ ಏನಾಗಿತ್ರಿ? ಎಲ್ಲಿದ್ದಾರೆ? When two driver of the said ambulance vehicle, petitioner Montri along with the daughters.
One submission, my lord. Today they have copy served, my lord. In instruction, I will take instruction.
He was traveling in that ambulance.
Ambulance.
ಇನ್ನೊಬ್ರು
ಅವರು ಆಂಬ್ಯುಲೆನ್ಸ್ ಅಲ್ಲೇ ಇದ್ರು.
ಅದರಲ್ಲಿ they have settled.
They are settled.
Then you verify, Mr.
I will verify, man.
Then we'll see whether records are necessary.
But maybe that another case 10,000 rupees has been awarded. They have filed giant memo. I will go through instruction and I will.
Liability accept ಮಾಡ್ದಂಗ ಆಯ್ತಲ್ಲ.
ಅದೇ I want to check
ಕಾಪಿ
it.
ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes, served copy, my lord.
Yes.
Including giant
Time
memo.
office is directed to secure original records. ಏನು? What is the problem? Yes. ಎಲ್ಲಾ ಕೋಟಲ್ ಆಗ್ತಿದೆ, ಇಲ್ಲಿ ಮಾತ್ರ. Yes.
Serial number 37.
And for the
Patri
petitioner
Vishal for
matter, my lord.
petitioner,
My lord, a week's time may be granted. We will comply with the office objection.
Raised on IA. What is that IA, madam?
I1 is the condonation of delay, my lord. I number 2 is bringing LRs on record.
ಏನು office objection ಏನು? What is that? You have to serve a copy to other side.
We'll serve it, my lord.
Affidavit is not shown, madam. You have to show that affidavit. Yes.
My lord will do the compliance. A week time may be given.
Finally, week's time is granted to comply that office objection.
Grateful.
Serial number 38. D. Nagaraj for
That's-
petitioner.
I pray for an
Government-
week's adjournment, my lords, to comply.
Furnishing a PF issue notice to R4. Week's time is granted to do the
Much
needful.
obliged, my lord.
Serial number 39.
Obliged.
Then serial number 40.
Few days back, I received the no objection. That's why, my lordship. Prior 2 weeks time, my lordship.
Yes, at the request of counsel for the petitioner, 2 weeks time is granted to comply office objection. Yes.
Serial number 41. Adi Narayan.
Appeal for petitioner.
Adi Narayanappa. Adi
File a
Narayan
memo.
for petitioner, government advocate.
Dispense the notice of R3, my lord.
Awaiting service of notice to R3.
Dispense the notice of R3.
Notice. Petitioner respondent
looking for
has been-
dispensation, right? Yes.
Has been died during the pendency of the petition without giving any successor. Who is that? R3. R3 is dead.
Yes.
Where is that report saying that he is dead?
ನಮ್ದೇ ಕೊಡೋಣ.
Interim order extended till next date. Yes.
Hearing interlocutory application matter, serial number 43, M. Venkatesh for appellant,
I'm for the
R.
appellant, my lord.
Shaktidhara,
I'm for the appellant, my lord.
Hmm.
In IA 1 of 2024 for substitute service in
Substituted
paper
service.
publication, my lord. Dinatanti Telugu newspaper circulated in Chitturu, Andhra Pradesh.
ಬೇರು ಅಂತ ಹೇಳಪ್ಪ ಒಂದು 5 ನಿಮಿಷ ಇಲ್ಲಿ.
IA 1 of 2024 is filed by the appellant seeking permission to take out notice to respondent number 4 by way of substituted service by paper publication. In which paper, madam?
Dinatanti Telugu daily newspaper.
Dinatanti Telugu daily newspaper circulated in Chittoor district, Andhra Pradesh. For the reason stated in that accompanying affidavit, IA 1 of 24 is allowed. Petitioner is permitted to take out notice to respondent number 4 by substituted service by way of paper publication in Dinatanti Telugu daily newspaper published and circulated in Chittoor district, Andhra Pradesh on or before
18th September,
hearing date.
16th October.
Yes.
My lord, I will praise 1 week time for take steps to R2, my lord.
Office objection complaint ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ ಸರ್.
For dismissal on 21/3/2021. Okay, so KL Srinivas ಯಾರು? Password.
Serial number 45, Suresh M. Lathur for appellant, this is Shivanegowda.
And for appellant in this case,
I am for respondent, my lord.
76 days delay in filing, my lord. Can kindly cut down the delay, my lord.
Yes, there is a delay of 76 days in filing an appeal. IA 1 of 2019 is filed for condonation of delay. Where was that affidavit? For the reason stated in that accompanying affidavit, delay of 76 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Yes, ready?
No, man. Next date will matter.
Is this matter of 4 weeks? Yes, they are not ready.
Serial number 46, adjourned. Serial number 47, PB Raju for appellant.
For appellant in this matter, my lord. And ECM matter, my lord. Case of injury, we are challenging.
ಆಗಿಲ್ವಾ?
Notice ಆಗಿಲ್ಲ. ಇದರಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮೆಮೊ ಕೇಳಿದ್ರು. We have produced the deposit memo, my lord.
Have you deposited before?
Please, my lord.
Yes. On what ground you are challenging, Mr.
My lord, the employer has deposited the entire award amount, my lord. Even though after depositing, my lord, the ECA court has directed this appellant to deposit 48,000, my lord.
Yes. Heard. Issue notice. Pay of statement and award dated 11th April 2019, passed by senior
ಅಲ್ಲ ಅವರೇ ಹಾಕಿದ್ದಾರೆ ವಕಾಲತ್.
Who are the tellers?
Children of late late Nanja Naika.
What is that relationship, Mr.?
Children, man. All are children.
Who is dead?
Nanja Naika is dead. Petitioner number 2.
Petitioner number 2. The LRs are the sons and daughter.
Sons and daughter.
Yes, who is appearing for other side? Notice
Government
Ogilva.
advocate, government advocate.
What about that other respondents, Mr.?
Respond number 1, we have to take steps in respect. of-
R1 is dead.
He dead, we'll take steps, man.
Some of are reporting death of R2 also.
Yes, my lord.
P2 now. Yes.
P2.
Steps
IA 1 of 23 is filed for condonation of delay of 34 days in filing an LR application to bring LRs of deceased petitioner number 2. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 34 days is condoned. Consequently, IA 2 of 2023 is allowed, abatement is set aside. IA 3 of 2023 is allowed, LRs of deceased petitioner number 2 is permitted to come on record. Learned counsel for the petitioner is permitted to amend the cast title. Weeks time is granted to pay the process, issue notice to respondent number 2 and 4. 2 weeks time is granted to file necessary application to bring LRs of deceased R1.
Say number 51, S. Kalyan Basavaraj for petitioner, Somnath H.
Petitioner. Hearing on behalf of the respondent number 4, 5 and LRs of respondent number 6, my lord.
You are appearing for 6.
Proposal, sir.
Yes. You are appearing for the LR.
LRs of R6 as well, my lord.
IA 2 of 2023 is filed for condonation of delay, bringing LRs of deceased R6. Heard the learned counsel for that appellant and counsel for LRs of respondent number 6. For the reason stated in that affidavit, delay is condoned. IA is allowed. Consequently, IA 3 of 2023 is allowed. Abatement is set aside. IA 4 of 2023 is allowed. LRs of deceased R6 is permitted to come on record. Learned counsel for the petitioner is permitted to amend the cast title. Yes.
He has made an application to vacate the interim order. The matter can be heard even next week also. I am ready.
Yes, you.
Any
amend
date
it.
may kindly be fixed in the next.
To amend it.
Please.
Yes,
Date may
permitted
kindly
to
be
amend.
fixed, my lord.
Reach this matter next week.
A date may kindly be
Big
fixed
Bharat next Wednesday. Yes.
next Wednesday.
Next Thursday, my lord. No, not Wednesday.
Yes.
First.
Serial number 52, Ramesh Kumar for petitioner,
petitioner,
Vishwanatha
this case,
TV, government advocate.
The respondent number 5 is died on 14/2/2024. The 5 LR applications, madam.
Notice agile.
Notice has to go.
No, madam. Please.
Issue notice on IA 1 of 2020.
And interim order be
LRs
extended.
of deceased R5.
Interim order be extended, madam.
Interim order granted earlier, if any, is extended till next date of it.
Serial number 53, PV Chandrasekhar for petitioner,
I appear for the respondent.
DGP LM Chidanandaya.
I have to file result and objections to IA, my lord. I did for 2 weeks.
Want to
time.
file an objection?
Yes.
1 week, my lord, because they are interested
No,
in the
no,
position.
it's a given, date given matter 27/9, my lord. It's a date given matter.
No, but they have filed an application for vacating.
That's why, my lord, I
No,
also.
after that vacating date has been given.
No, my lord, even
even-
before that,
my
caveat,
Wait.
caveat was filed. Caveat was there. After that, my lord, interim order granted, I will file resign and send objection to IA, my lord.
My lord, it-
The
according
petitioner
to
filed
him,
restraint
my lord,
from
it
the
is
delimit
granted
that
by way of
properties of-
public auction, my lord.
That is on merit, sir.
That properties release this matter. HAGP Sunil Kumar, who filed an caveat, is directed to notice. None appear for the caveator has not appeared. What?
ನಾವೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಬರ್ದಿದ್ರೆ ಕರ್ಕೊಂಬರಕ್ಕಾಗಲ್ಲ
If
ಅವಾಗ
a
ನಾನು
party
ಅವ್ರನ್ನ
has engaged the caveat is not appeared, then that interim order has been granted.
Granted.
It is true, my lord, but the fact of the matter is subsequently.
I will file objection.
Wait a minute. Let him make a submission. Why dear?
The issue is, my lord, here, the petitioner are claiming to be the grandchildren of Ganapati Nayak filed a petition. Claiming that, my lord, this land was granted by way of a public auction way back in the year 1940. My lord, on the basis of that, my lord, the claim is that the fifth respondent husband purchased his property in the year 1993.
Yes.
And therefore, there is a violation of PTC. My lord, your lordships have consistently held, if the land is granted by way of an auction, it is not a granted land under the PTCL Act. But the very same Assistant Commissioner, part 2 orders.
one allowing the application, setting aside my sale. There is another order passed in respect of the very same survey number, in respect of other portion of the property, upholding the sale deed.
Yes, we'll consider next week.
Yes.
You file
Next
an
week, my
objection.
lord.
You also secure the records, Mr. Governor.
No.
The time permits, we can hear the.
First week of September.
No, my lord. Your lordship may have next week, my lord, because
Sir,
it's
one
covered by your lordship series.
My lord, that is not so, my lord.
Is this matter on 2nd September?
2nd September.
Yes.
Sorry, madam. Previous matter, interim order is to be extended.
Interim order extended till next date of it. 51. Yes.
Serial number 50, B group matter, serial number 54, B Latif for petitioner, H Mohan Kumar.
Lord, said
Yes, Mr.
challenging the order passed by the deputy commissioner and the assistant
Grantee or purchaser?
purchaser,
Purchaser.
please.
Yes.
Lord, originally the land was granted in the year 1960
1960 grant.
and subsequently, Lord, that is 4 acres of land in survey number 29 of Chaudenahalli village of Belur Taluk. Subsequently, that property has been purchased by petition number 1 in the year on 1981.
1981.
Please,
Yes.
that sale deed is produced at annexure C.
Yes.
And again, petitioner number 1 sold the property to petitioner number 2 on 4/4/2007
Yes.
at annexure D.
Yes.
And the application filed before the assistant commissioner in the year 2008.
Where is that?
Please, Lord.
2007 and 8.
7 and 8.
2007 antandre, it was sold when? 98 allala?
First sale 81, that is,
1981. Okay.
please, Lord.
81 antandre,
27 years, sir. 26 years.
again that we have to wait for the decision of full constitutional validity. Yes, who is appearing for other side? Yenagidare a matter? Constitutional validity matter yenaitadu?
Actually, it is going on. Next week.
ಮತ್ತೆ reserve ಆಗಿದೆ ಅಂದ್ರಲ್ಲ ಯಾರೋ? You verify?
Finally, date was given.
Yes. When it is posted ಅಂತ verify. Yes, leave this matter after 2 weeks.
Interim order may be extended.
Granted earlier is extended till next date of hearing.
Great.
Serial number 55, 56 adjourned, serial number 57, Poonam S. Patil, Siddharth HM for petitioner, C. Shankar Reddy, government
Respondent
advocate.
number 2, my lord. May kindly pass forward.
Password. What is this matter, madam?
Which we are challenging the order passed by respondent number 1 government. So. this is-
Yes, password.
Yes.
Final hearing old ಮುಗಿಸ್ಬಿಡಿ ಮಧ್ಯಾಹ್ನ.
Final hearing matter, serial number 58 adjourned, serial number 59, Shripad V. Shastri for appellant, Janardhan Reddy.
Well, I am for appellant, madam. Well, what happened in this case is insurance company earlier preferred an appeal that has been allowed and pay and recovery order is passed. I filed the, I produced that appeal. Well,
Near we have filed an appeal. In view of Mukund.
only on now, only question.
At the time of the tribunal was taken income 4,000 rupees instead of 8,000 rupees. So at the time of my appeal, the petitions was not appeared. So hence my appeal was disposed. In para 6 of the judgment, the tribunal, the court was discussed. In case appeal fail ಮಾಡಿದ್ರೆ enhance ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಒಂದು para discussion ಆಗಿದೆ. In view of that ಇದೊಂದು para add ಮಾಡ್ಬಿಟ್ಟು ಇದು enhance ಆಗುತ್ತೆ ಸೊ ಆಗುತ್ತೆ.
Well, as far as quantum is concerned, my lord,
After reconsidering the case and if that claimant has preferred an appeal, then the income would have been considered as 8,000 per month. Therefore, compensation order of tribunal is found to be just and proper. Accordingly, on that quantum also appeal is liable to be dismissed. The tribunal has granted. Yes, Mr. Shastri.
yes, it's a case of death, my lord.
Now, what you
Husband
say
is the
about
only
that
claimant.
finding of this court regarding that?
Yes, quantum, my lord, kept open, my lord. As far as quantum is concerned, my lord, the earlier court.
kept open, rating underline ಮಾಡಿದ್ದೀನಿ.
After reconsidering the case, if the claimant had preferred an appeal, then the income would have been considered as 8,000 per month. ಈಗ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
4,000 ತಗೊಂಡಿದ್ರು. ಅದು ನನ್ನ ಅಪೀಲ್ ಮುಕಂದ್ ಯೋಗನ್ ಕೇಸ್ ಪ್ರಕಾರ ನನ್ನ ಅಪೀಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಯ್ತು.
8,000
ಅಪೀಲ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಂದು
compensation awarded with tribunal is found to be just and proper. Accordingly, on the quantum also, appeal is liable to be dismissed. ಎಲ್ಲ ಇತ್ತು kept open ಅಂತ.
ಅಲ್ಲ kept open ಅಂತಲ್ಲ. ಇನ್ ಕೇಸ್ ಅಪೀಲ್ ಫೈಲ್ ಇವ್ರು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ ಸರ್, ಅದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, ನಮ್ಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, ಅವ್ರಿಗೂ ಸರ್ವಿಸ್ ಅಲ್ಲ. ಆ ತರ ಆಗಿ ನನ್ನ ಕೇಸಲ್ಲಿ ಇವ್ರು ಸರ್ವಿಸ್ ಆಗಿದೆ, ಅಪೀರ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲಿ ಆಗಿದ್ರೆ ಇನ್ಕಮ್ 8,000 ಮಾಡಿ ಅಂತ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ.
ಅದೇ ಸರ್, ಅದೇ ಹೇಳ್ತಾರೆ. ಅದೊಂದು ಆಸ್ಪೆಕ್ಟ್ ಇರೋದು ಅಷ್ಟೇ.
Quantum, my lord, interest is reduced in their case, my lord. I am not much disputing on that aspect. Quantum, my lord, it's a 2013 accident. My lord, for husband death, my lord, wife is claiming compensation.
After reconsidering the case, and if the claimant has preferred an appeal, then that income would have been considered at 8 per month. Therefore, compensation awarded by the tribunal is found and just and proper ಅಂದ್ರೆ ಹೆಂಗೆ ಅದು? What is that?
ಅದರಲ್ಲಿ ಅವ್ರು ಹಾಕಿಲ್ಲ ಅಂತ ಉದ್ದೇಶದಿಂದ ಆತರ ಬರ್ದಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅಷ್ಟೊಳಗೆ ಇವ್ರು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. 2018 ಇವ್ರು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ನನ್ನ ಅಪೀಲ್ ಅಲ್ಲಿ ಇದು ನೋಟಿಸ್ ಸರ್ವಾಗಿದೆ. ಸೇಮ್ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇವ್ರು ಯಾರು ಅಪೀರ್ ಆಗಿಲ್ಲ, ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಯಾರೋ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ನನಗೆ ಶ್ರೀಪಾದ್ ಶಾಸ್ತ್ರಿ ಹೇಳಿದ್ದು. ಆಮೇಲೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ನನಗೆ ಇಂಟಿಮೇಷನ್ ಕೊಟ್ರು.
No, I think it has to be recalled, Mr.
Appeal is, it may be topographical mistake because, my lord, the further sentence says their appeal is required to be dismissed on quantum. My lord may kindly see further sentence accordingly.
Finding of the learned single judge that the compensation awarded by the tribunal is found just and proper.
No.
Again, it is not proper.
Next sentence may kindly be seen.
Accordingly on the quantum also, the appeal is liable to be dismissed.
No, my lord, because on that case, my lord, I am not served with the notice.
That is the ground for recalling. ಏನ್ ಒಬ್ಬೊಂದು ಜಡ್ಜಿ ಒಂದೊಂದು ಆರ್ಡರ್ ಮಾಡ್ಕೊಂತ ಹೋಗೋದ ಒಂದೇ ಕೇಸ್ ಮೇಲೆ? See, this other bench said quantum is just and proper. Now I say that quantum is not just and proper, therefore it has to be enhanced. On same judgment, there is in a this thing.
There may be correction required in the para 5 of the judgment.
You file an application there.
My lord, because, my lord, the earlier court said it is 8,000 per month, but tribunal consider 4,000. So, my lord, just and proper
8,000 consider ಮಾಡಿದ್ರು, overall compensation just and proper ಅಂತ ಹೇಳಿರೋದವರು.
ಅಲ್ಲ ಮುಂದೆ ಹೇಳ್ತಾರೆ accordingly on the quantum also the appeal is liable to be dismissed ಅಂತ ಹೇಳ್ತಾರೆ.
Quantum also just and proper ಇದೆ, ಅದಕ್ಕೆ dismissed ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. It's in a simple language. It is there. There is no ambiguity.
My lord, as my lord suggested, it's a very good ground for recalling that order.
Yes, you have to, because when is that your appeal is filed?
2019.
My appeal is filed on 21/1.
As on that day, it was pending.
Yes, it is pending.
Then why you have not brought to the notice, mister?
No, I am not served with the notice in the insurance company appeal.
ಸರ್ವಾಗಿದೆ.
ಸರ್ವಾಗಿಲ್ಲ.
For advocate.
No, I am.
ಸರ್ ಸರ್ವಿಸ್ ಆಗಿದೆ ನೋಡಿ ಸರ್.
Served ಅಂತ ಐತಲ್ರಿ?
ಸರ್ವ್ಡ್ ಇದೆ ಸರ್.
Served unrepresented, my lord. Wakalat not filed.
No, that notice is served to your party. ಅದನ್ನು ವೆರಿಫೈ ಮಾಡಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ whether it is served or.
ಅದನ್ನ ನೋಡಿದ್ರು ಸ್ವಾಮಿ, ನೋಡ್ಬಿಟ್ಟು ಸಾಹೇಬ್ರ ಅವತ್ತರ.
ಮತ್ತೆ ಆಯ್ತು, ನೀವಾದ್ರೂ ಹೇಳ್ಬೇಕಲ್ರಿ, ನಿಮಗೆ ನೋಟಿಸ್ ಆಗಿರ್ಲಿಲ್ವಾ ಅವಾಗ?
ಎಸ್, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗಿದೆ, ಅವ್ರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ನಮ್ಮ ಕೇಸಲ್ಲಿ.
ಶ್ರೀಪಾದ್ ಶಾಸ್ತ್ರಿ ಹೇಳಿದ್ಮೇಲೆ ನನಗೆ ಗೊತ್ತಾಗಿದ್ದು. ನಾನು ರೀಕಾಲೆ ಮಾಡಿ ಕಾಮನ್ ಆಗಿ ಆರ್ಡರ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ಸೋಣ ಅಂತ ಹೇಳಿದೆ ಅವ್ರಿಗೆ.
ಎಲ್ಲಿದೆ ನೋಟಿಸ್ ಆಗಿದೆ? ಯಾವತ್ತು ನೋಟಿಸ್ ಆಗಿದೆ? There is no possible sentence. The matter is referred back to that court least before the appropriate bench having in roster 18/12/2021. 18/12/2021 ಅಲ್ಲಿ ಇಬ್ರು ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ಲೋಕ ಅದಾಲತ್ ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಲ್ಲ ಅಂತ ರೆಫರ್ ಮಾಡಿಸಿದೀರಾ. but nobody has brought to the notice of the court, Mr.
My lord, in para 4, anyway, my lord, I will do the
Memo
needful.
is seeking a dispensation notice, owner of the vehicle has liabilities. 23 ಕೆಳಗಡೆ ಆಯ್ತು 21 ನಲ್ಲೇ ಲೋಕ ಅದಾಲತ್ಗೆ ರೆಫರ್ ಆಗಿದೆ. ಇವರ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಆಸ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಆಯ್ತು ಅದನ್ನ ರಿಕಾಲ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. Yes. You also has to say no objection for recalling.
Yes, sir.
Yes. Please this matter after 2 weeks.
Serial number 60 adjourned, serial number 61, Gopal Krishna N for appellant, EI Sanmati, Ashok N Patil. Serial number 61.
Appearing for respondent 4, my lord.
I have not filed my wakalat minutes. I'll collect a copy from Gopal Krishna.
Now you are appearing for
Respondent number 2.
respondent number 2.
Oh.
You are appearing for
Respondent number 4, my lord.
ಇಬ್ರು ಇದೆ ಎರಡು ಇನ್ಶೂರೆನ್ಸ್.
ಎರಡು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಇದೆ.
Yes. At the request of counsel for R2 next week.
Yes.
Leave this matter next week.
After 2 weeks.
2 weeks.
Serial number 62, Shripadvi Shastri for appellant, Janardhan Reddy.
Yes,
My
Mr.
lord, I am for appellant, my lord.
Yes.
My lord, doctor not examined and 72, sorry, my lord, sorry, my lord. Sorry, my lord. 1817. My lord, it's a case of injury, my lord.
Yes.
Only on quantum. Liability and negligence is not in dispute.
Yes.
My lord, extent is of the year 2017, man.
Yes.
11,000 is required to be considered instead of 8,000.
Yes.
My lord, the facts of the case is, my lord, he is aged 43 years.
Yes.
My lord, claims to be earning is a tender coconut plucking work he is doing. 1,000 rupees per day anta ಹೇಳ್ತಾನೆ. My lord, injuries may kindly be note, my lord.
Yes.
Fracture of right ulna, fracture of femur, fracture of ribs 7, 8, 9 and 10. Fracture of pelvis, page number 8, para number 13 onwards, my lord.
Yes.
Fracture of pelvis and fracture of thumb, my lord. Total 1, 2, 3, 4, 5, 6, 7, 8 fracture is there, my lord.
Yes.
My lord, he was treated as inpatient in private hospital for 25 days. My lord, total 4 surgeries underwent.
Yes.
My lord, the implant is still in situ. It required a removal. According to doctor, my lord, 60,000 required for that. My lord, the subsisting disability is, my lord, after calculation of per limb disability. My lord, doctor assesses 23.24%. My lord, tribunal consider only 22%. My lord, one by one, my lord, the pain and suffering. My lord, 50,000 awarded seems to be little bit lower side, my lord. Pain
Now,
and
what
suffering.
you say about the disability, Mr.
My lord?
Disability tribunal has taken 22%.
22%. My lord, the
pain and agony, loss of income during the treatment. Treatment ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
26 days is inpatient.
8
loss of amenities, my lord, with incidental, only 20,000 awarded, my lord, seems to be lower side because
Loss of
the
amenities
subsisting
and
disability, my lord.
Yes.
He can't difficulty in walking, long standing, squatting and restriction of movement. My lord, resulted in more than 23% whole body disability.
Disability.
So, my lord, his age is only 40 to 43 years. So 20,000 seems to be lower side, my lord.
And 10% to the right.
My lord, medical expenses, my lord, I have produced 3,12,900 rupees, my lord, that has been allowed, my lord.
Yes.
Loss of earning, my lord, at least 6 months, my lord, is taken repeated treatment. 8,000 is considered instead of 11,000 while granting loss of earning for the laid up period, my lord, that is required to be enhanced.
Yes.
As far as future loss is concerned, my lord, even though the court considered 22% whole body disability seems to be just marginally lower side, but income 8,000, it is required to be enhanced to 11,000.
Yes.
And future medical expenses, my lord, 15,000 is awarded.
Early the discussion.
But it is found in.
Yes, F. Implant is body removal, same is must cost 60 to 70 PW tax. The petitioner has removal of surgeries, hospital approximately 60. Not produce any supporting document to prove the same. Hence it is just and proper to 15,000. Yes, that will consider.
Some aspects only
My lord, he required actually 4 implants has been put, my lord. That is why doctor said 60,000. In 4 places it is to be removed.
Yes. Yes.
interest to 8%.
Yes, that will consider. Third. Sri Shastri Learned Council appearing for the claimant has contended that at the time of the accident, he was earning 30,000 per month. Tribunal has assessed notional income of the claimant as 8,000 per month is on lower side. Secondly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 25 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Lastly, he has contended that due to that accident, claimant has undergone 4 surgery. The doctor has deposed that he requires 60 to 70,000 for removal of implant. The future medical expenses awarded by the tribunal 15,000 is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Reddy Learned Council appearing for insurance company has contended that even though claimant has claimed that he was earning 30,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income as 8,000 per month. Secondly, he has contended that considering that evidence of doctor and injury suffered by the claimant and considering that medical records, the compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses, and future medical expenses are just and reasonable. The interest awarded by the tribunal 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. Peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 26/11/2017 due to rash and negligent driving of driver of car bearing registration number KA01 ML 1775. Due to that accident, claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed whole body disabilities 22%. Even though claimant has claimed that he was earning 30,000 per month, he has not produced any document to establish the same. Notional income has to be assessed as per the guidelines for 2017. 11,000 has to be considered. At the time of the accident, he was aged about 43 years. Multiplier applicable is 14. Accordingly, loss of future earning has been reassessed as follows.
11,000 into 12 into 14 into 22%, 4,06,560.
4,06,000.
560.
Due to that accident, claimant has suffered the opposite injury. inpatient for a period of 25 days, suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, inclined to enhance the compensation for pain and suffering from 50,000 to 60,000. Loss of amenities, conveniences, food and nourishment from 20,000 to 50,000. Loss of income during the later period has to be granted for 5 months. In respect of future medical expenses, the claimant has suffered the above said injury. He has undergone 4 surgery. Doctor has deposed that he required 60 to 70,000 for removal of the implant. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for future medical expenses from 15,000 to 35,000. Will not carry any interest. The enhanced compensation amount carries 6% interest. Yes, appeal is allowed in part. Yes.
Serial number 63, V.B. Siddaramaya for appellant, N. Krishnaswamy. Serial number
Come in.
63,
None appears. Reach this matter after 2 weeks.
serial number 64, R. Shashidhara for appellant, connected matter, B.S. Umesh.
Yes.
My appeal is for enhancement of compensation.
ಅವ್ರದಕ್ಕೇನು
Liability challenge ಮಾಡಿದ್ರು.
ಏನು on what ground?
The injured is not involved in the said accident ಅಂತ ಅವ್ರು.
Where is
Did not
Umesh?
sustain injuries on the said accident ಅಂತ
ಬಂದಿದಾರಾ?
ಅಂತಾರೆ.
ಬಿಸಿಲಿಲ್ಲ ಅಲ್ಲ ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಇದಾರಾ? ಪಾಸ್ ಓವರ್. ಎಸ್ ಪಾಸ್ ಓವರ್.
Serial number 65, Gopal Krishna N for appellant, S. Krishna Kishore.
ಹೋದ ವಾರದಿಂದ ಈ ವಾರಕ್ಕೆ ಹಾಕೊಂಡ್ರೆ
ಹ್ಮ್.
Claim petition was dismissed, my lord.
ಹ್ಮ್.
This is about a casual laborer. There is
ಹ್ಮ್.
no employer and employee relationship. ಅದಕ್ಕೆ claim petition dismiss ಆಗಿದ್ದಕ್ಕೆ appeal ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಅವರು? ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಹೋದ ವಾರ ಟೈಮ್ ತಗೊಂಡ್ರು ಸ್ವಲ್ಪ. ಹೋದ ವಾರ ಟೈಮ್ ತಗೊಂಡ್ರು ತಮ್ಮ ಮುಂದೆ.
ಏನಕ್ಕೆ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ಅಥವಾ?
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡ್ತೀವಿ.
Yes. None appears for the appellant. Reach this matter after 2 weeks.
Serial number 66, Hudson. Past or matter,
One submission. Serial number.
For the appellant, my lord.
63,
my lord.
63.
3 months.
19 ಇದೆ ಒಂದು.
Refer to look at ಮಾಡ್ಸೈತಿ.
ಮಾಡಿಸಿ.
63, Siddaramaya.
Please, please.
At the request of the parties, refer this matter to Lok Adalat. Yes.
past or matter. Serial number 9,
Yes.
serial number 9, Sandhya D for petitioner.
Pass over.
Serial number 10, F.S. Dabali for appellant, connected matter, Sripad V. Shastri.
ಎಲ್ರಿ ಅವ್ರು ಕೇಳಿದ್ರ ದಬಾಲಿ ಅವ್ರು?
ಹೇಳಿದ್ವಿ ಸ್ವಲ್ಪ ಕೆಳಗಡೆ 25 ಅಲ್ಲಿ ಇದಾರೆ.
ಆಯ್ತು ಪಾಸ್ ಓವರ್ ಮಧ್ಯಾಹ್ನ. Yes.
Serial number 11, B.M. Siddhappa for appellant, Ravish Benny.
Yes. Where is Ravish Benny? Pass over.
Serial number
ನಿಮ್ದು ಯಾವ್ದು ಮಿಸ್ಟರ್ ರವಿ?
35 ಇದ್ದಾನೆ.
ಇದರಾ ಅದರ್ ಸೈಡ್? ಹಾ ಎಸ್ ಕರೀರಿ.
serial number 12, Nagaraja Hegde for appellant, Ravish Benny.
Yes, pass over.
Serial number 13, R. Shashidhara for appellant, P.P. Raju.
Respondent in case of injuries, my lord. Act evidence ಏನಿಲ್ಲ. But fracture of third, fourth and fifth metatarsal, fracture of third and fifth metatarsal base, my lord. Right and left metatarsals. Total, my lord, 73,000 is awarded. 11,000 medical expenses bills ಇದೆ.
11,000 ಮೆಡಿಕಲ್ ಬಿಲ್.
ಹಾ.
ಏನು ಇಂಜುರೀಸ್ ಏನಿದೆ?
3, 4, 6. Metatarsal bone.
Para toll, my lord.
Metatarsal bone of right foot. Seen fracture of the right base. 5 metatarsal bone. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್?
73,000 ಕೊಟ್ಟು 23 ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 25,000 ಕೊಟ್ಟಾರೆ. ಕನ್ವೆನ್ಸ್ ಫುಡ್ ನರಿಶ್ಮೆಂಟ್ 5,000 ಕೊಟ್ಟಾರೆ. ಮೂರ್ ದಿನ ಇನ್ ಪೇಷಂಟ್ ಇದ್ದಾರೆ.
ಆಯ್ತು, ಎಷ್ಟು ಎನ್ಹಾನ್ಸ್ ಮಾಡಬಹುದು? Doctor has not been examined. Yes. How much it can be enhanced, Mr. Shishidhar?
Another 50,000 maybe.
3,000 ಇಲ್ಲ.
Loss of income during treatment 25 to 30,000.
Yes. 30,000 with interest.
ಆಗ್ಬೋದು.
We'll do it one thing. 73,000 na will enhance to 1 lakh. Interest as it is 9% ಇದೆ, it will be continued for 9%. ಅಲ್ಲಿಗೆ ಸರಿ ಆಗುತ್ತೆ. Round figure ಮಾಡ್ಬಿಟ್ಟು interest will be continued. So and so learned counsel appearing for the claimant has contended that due to that accident, claimant has suffered grievous injury. He has spent 11,000 rupees for medical expenses.
2008.
The overall compensation awarded by the tribunal, 73,000 is on lower side. Hence he sought for enhancement of compensation. Per contra, Sri Raju learned counsel appearing for insurance company has contended that the injuries suffered by the claimants are minor in nature. He has spent only 11,000 rupees for medical expenses. Considering, and he has not examined the doctor. Considering that wound certificate exhibit P5 and medical bills, the overall compensation awarded by the tribunal is just and reasonable. Hence sought for dismissal of the appeal. Heard the learned counsel for the parties. Whereas judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 11/8/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA 17 EC 1606. Due to that accident, claimant has suffered the following injury. He has spent 11,000 rupees for medical expenses. And he was inpatient for a period of 3 days. Considering that evidence of doctor, considering that evidence of PW1 and wound certificate and medical records, I am of the opinion that in addition to that compensation awarded, the overall compensation awarded by the tribunal, 73,000 has to be enhanced to 1 lakh with 9% interest. Accordingly, the appeal is disposed of.
Till number 16, Gopal Krishna and for appellant, connected matter, B Latif.
Shivanagowda, Passover.
Serial number 17, Vivekananda TP for appellant, C.R. Ravishankar.
Respondent. Injury case.
ಇಲ್ಲಿ ವಿವೇಕಾನಂದ ಬೆಳಗ್ಗೆ ಇದ್ರಲ್ಲ, ಏನ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಇದೆಯಾ?
ಇದು ಅದೇ ಇದ್ರು ಚಾಟ್ ಪ್ರಕಾರ ಮಾಡಬೇಕು.
Where is
24%, 24.3 for whole body ಹಾಕಿದ್ದಾರೆ. Criminal has taken 18%. ಅದು ಒಂದ್ ಸ್ವಲ್ಪ ಇದೆ. ಪ್ಲಸ್ ನೀವು ಇದು ಚಾಟ್ ಪ್ರಕಾರ ಹೋದ್ರೆ
enhancement. Where is he? Passover. You get him if he comes. Passover. Madhyana, you don't. Yes. At the request of respondent number 6, release this matter next week.
Serial number 20, Manohar N for petitioner.
No, that Ravi Shankar, nominal enhancement of that disability and notional income, if he is only on that ground, we'll consider. If he wants that future prospects and all, I will urgent that for next week. Yes, your presence is not necessary. Nobody else. Passover.
Serial number 20, Manohar N.
Yes, kodi. Yenadu kodi.
Subjection first time.
Yenide?
Two, either application, pin code, parties ranking, chronological.
Yes, none appear for the petitioner. As a last chance, 2 weeks time is granted to comply of subjection.
Serial number 33, Shivakumar P for appellant, C. Lakshmi Narayana,
For appellant,
Yes.
behalf of Lakshmi representing.
I am filing memo for disposition for R2.
Yes.
Satisfy
Notice.
ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ. ಮಾಡ್ಬೋದು.
Consider,
ಮಾಡ್ಬೋದು.
if you argue any other grounds, we will adjourn it.
That one.
Yes. Notice issued to that respondent number 2 written with postal sera, not claimed, hence service held sufficient. Yes, Mr.
My lords. This case, date of accident is 30th/4/2016.
2016.
Our contention is that 8,000 they had taken as an income. As per chart 9,500.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
8,000.
15,000, they have no documents.
ಎಷ್ಟಿದೆ ಇದ್ರಲ್ಲಿ ನೋಷನಲ್?
500.
9,500. ಮತ್ತೆ
Disability 36% ಹೇಳಿದ್ದಾರೆ, ಬಟ್ ಅದರಲ್ಲಿ
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
5%.
ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್? ಹೋಲ್ ಬಾಡಿ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ? ಅಲ್ಲ, ಲಿಂಬ್ ಡಿಸಬಿಲಿಟಿ
As per exhibit, they produced exam.
ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ? ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ? ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದೆಯಾ?
ಇಲ್ಲ ಸರ್.
ಏನ್ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್?
36% ಅಂತ ಹೇಳ್ತಾರೆ.
ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್ ಅಲ್ಲಿ? ಎಲ್ಲಿದೆ 36%?
ಜಡ್ಜ್ಮೆಂಟ್
ಎಲ್ಲಿದೆ? ಯಾವ ಪ್ಯಾರಾದಲ್ಲಿ? How come it is 5%, mister? If it is 36?
As per they produced extract, my lord, there is no fracture in.
ಯಾವ್ದ್ರಲ್ಲಿ?
They produced.
ಇದ್ ಬಂದಿಲ್ಲ, ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ.
Recent X-ray shows that there is no evidence to PW to assess the physical disability in lower state.
ಎಲ್ಲಿದೆ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಡಿಸ್ಕಷನ್? ಎಲ್ಲಿದೆ? 35 ಪ್ಯಾರಾ 9 ಓದಿ. ಪ್ಯಾರಾ 9 ಅಲ್ಲಿ ಇದೆಯಾ? You read ಪ್ಯಾರಾ 9.
PW1 stated that immediately after the accident, he was shifted to government hospital in Kerala. And after first aid treatment, he was shifted to Victoria Hospital, later in Apruti Hospital, Nelmangla, within wherein he was treated as inpatient for 10 days. Corroborate petitioner has produced the exhibit P5 wound certificate. It discloses that the petitioner has sustained the breast injury, great laceration of the second and third thigh, right, and the operation over the left forearm. The doctor has an opinion that the injury number 1 is grievous and 2 and 3 are simple in nature. Petitioner has examined Dr. Nagaraju B.N. who stated who has assisted disability PW4 who produced the exhibit 316 extract report. Extract 70, extract 317, extract PW4 is supposed that the term 4/8/2018 assessed disability in the petitioner and petitioner complaints of deafness, the right foot and ankle with pain, unable to walk normally, sit down and sit cross legs, squat. They do his profession in carpenter. An examination, the petitioner was unhealthy care over the right foot and ankle with right ankle. Recent X-ray shows that evidence of fracture PW2 has assessed physical disability of the lower limb 37% and the whole body 12%.
Tribunal has considered that 5.
House.
Yes.
And pain and
ಕೊಟ್ಟಿದ್ದಾರೆ. Pain and suffering
20,000.
Medical expenses, food and nourishment.
550.
Loss of income during the treatment. ಎಷ್ಟು month? 1 ತಿಂಗಳು?
10 days in
10
patient.
days ಕೊಟ್ಟಿದಾರ.
2,670 rupees ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
Loss of immunities.
10,000 rupees are provided.
Interest 6% ಕೊಟ್ಟಿದಾರ. Yes, that's all. Dali. So and so learned counsel appearing for the claimant has contended that due to that extent, he has suffered grievous injury. Doctor has been examined as PW4. In his evidence, he has deposed that claimant has suffered 37% disability to lower limb and 12% to whole body. Tribunal has assessed whole body disabilities 5% is on lower side. Secondly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 10 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses are on lower side. Hence, he sought for enhancement of compensation. Per contra, so and so learned counsel appearing for insurance company has contended that even though doctor has deposed that claimant has suffered 37% disability to lower limb and 12% to the whole body, as per that X-ray produced as exhibit P16 shows no evidence of fracture. ಅಂತ ಡಾಕ್ಟರ್ ಹೇಳ್ಯಾರನ್ರಿ ಅಥವಾ ಕೋರ್ಟ್ನವರೇ ಎಕ್ಸ್ರೇ ನೋಡಿ ಹೇಳ್ತಾ ಇದಾರ? ಹೆಂಗ್ರಿ ಕೋರ್ಟ್ನವರೇ ಎಕ್ಸ್ರೇ ನೋಡ್ಬಿಟ್ಟು ಫ್ರಾಕ್ಚರ್? Therefore, tribunal has rightly assessed whole body disability is 5%. Further contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses just and reasonable, sought for dismissal of appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 30/4/2016 due to rash and negligent driving of driver of car bearing registration number KA 527914. Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 10 days. Doctor has been examined as PWF4. In his evidence, he has deposed that claimant has suffered physical disability of lower limb at 37% and whole body is 12%. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 10%. Even though claimant has claimed that was earning 15,000, notional income has to be assessed as per the guidelines 9,500. The multiplier applicable to that age group is 9. Accordingly, loss of future earning has been reassessed as follows.
9,500 into 12 into 9 into 10%, 1,02,600.
Due to that accident, the claimant has suffered the aforesaid injury. Inpatient for a period of 10 days, suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, inclined to enhance the compensation for pain and suffering from 20,000 to 35,000. Loss of income during the later period has to be granted for 2 months. Loss of amenities has to be enhanced from 10,000 to 25,000. Other head compensation awarded by the tribunal is just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as well.
Serial number 44, L. Srinivas for appellant. 44.
ಏನಿದು KL ಶ್ರೀನಿವಾಸ್ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
Issue notice. Issue notice to respondent.
Serial number 57, Poonam S. Patil, Siddharth HM for petitioner. Sri Shankar Reddy. Serial
Yes,
number
ma'am.
57.
IP for petition.
Yeah, no, what is this matter, madam?
This is not, sale permission was set aside by DC. So on the ground that there are petitions have made allegations of forgery against the respondents.
Yes.
DC Milords cancels the permission. The respondents challenge that before this honorable court by way of a writ petition. In the writ petition notes, single judge notes passes direct says DC does not have the jurisdiction to pass such an order. It has to be the government because the government who has allotted the permission. And this honorable court categorically directs Milords that DC's order should be considered as a report by the government and order should be passed. Now Milords impugned orders annexure R by the state government pursuant to this honorable court's order.
Yes.
My grievance is very limited, Milords. That the direction of this honorable court was consider DC's report as DC's order as a report. Other than Madilla, Milords. Annexure R 191 is an impugned order.
R1.
Yes, annexure R, page 191.
Yes.
Before that, may I take your lordships to the court order passed by this honorable court, which is Milords at annexure P, page 159. So that we understand Milords what this honorable court actually did. 159 Milords.
159.
Yes, this is the order passed by this honorable court. Its
Yes.
operative portion of this order, Milords, your lordships will find.
No, why that grantee is also challenged that he's a grantee or
He's a purchaser, Milords.
he's a purchaser?
He's a purchaser, 2001 Milords.
For-
I am the original grantee, Milords. LR, legal,
You have disputed that you have not
signed, Milords. So, what happens, Milords, and on the application seeking sale permission, that is the allegation that my signatures were forged. In fact, which is why even lower court records were summoned, Milords, by the respondents themselves.
no, when you yourself is not ready to sell that property, what is the necessity of considering that government and all then?
Milords, what happened was, 2001 ಅಲ್ಲಿ land resumption ಆಗುತ್ತೆ. ಯಾರಿಗೋ ಬೇರೆಯವ್ರು ಮಾರಿರ್ತಾರೆ, resumption order ಬರುತ್ತೆ. That is challenged by the person who was aggrieved who had purchased the Milords. Now, while that appeal is pending, the sale permission is granted. Not, it is my contention.
No, the permission is granted in respect of the very same purchase.
Very same, not purchase, Milords. The sale permission, Milords. Generally, sale permission is.
Yes, permission is then how that this respondent is concerned?
Milords, this respondent, Milords, what happens, Milords? A sale deed was executed pursuant to that thing, Milords.
No, sale deed is executed in respect of the different purchase.
No, same property, Milords.
No, property is same. Earlier you have sold that property to one X. That has been resumed.
Yes.
Now permission is granted.
Yes.
Sale deed in respect of the very same original purchaser or is a different?
Different purchase. It's a different purchase, Milords. Milords, what I do, Milords, I challenge that sale permission, Milords, before DC, Milords. This or DC's order comes to be challenged in this honorable court's order, which I was running through your lordships, Milords. 174 is the operative.
Government has said that permission is granted.
They've upheld that permission, Milords. Without my grievances, Milords, without considering the direction of this honorable court to consider DC's order as report. Now note the Milords 174 only is a direction by this honorable court, Milords.
Yes.
Before taking to the impugned order, Milords, I would like to read this 174 only, Milords.
Yes.
If I may read only the relevant portion, Milords, which is as clause 3.
Yes. She is doing good. I think you continue.
Yes.
Yes,
So, clause 3 only, sir.
Yes. Yes, I will grant type. Wait. Yes.
It's clause 3 only, Milords. This honorable court directs the secretary shall consider such order as the report and the other materials strictly in accordance with law for a decision on cancellation of the permission granted on 6/3/2004. But after extending due opportunity to the petitioner and the contesting respondent, and if considered necessary to the concerned others.
Consider that order as a report on the material strictly in accordance with law.
Yes.
Now that it is like a fresh consideration by the government.
Yes, they did not, the reference is made to DC order, Milord, but it's not considered as report at all. Totally de novo, Milords. Annexure R, as I was pointing out, Milords, is the impugned order at page 191.
Yes.
Yes. ಇಲ್ಲಿ notes the preamble and all reads the facts, notes the earlier disputes between the parties.
Yes.
If I may take your lordships to page 196 ಅಲ್ಲಿ notes. ನಾನು ಓದ್ಬೋದು.
Yes.
I'm reading to the fourth paragraph in the
Yes,
at
yes.
page 196.
Yes.
ಶ್ರೀಮತಿ ಗೋವಿಂದಮ್ಮ, ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ, which are who are the petitioners.
Yes.
ಶ್ರೀ ರಾಜಪ್ಪ ಮತ್ತು ಶ್ರೀಮತಿ ರುಕ್ಕಮ್ಮರವರು ಪರವಾಗಿ ಅವರ ವಕೀಲರು ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು, ಅದರಲ್ಲಿ ಗೌರವಾನ್ವಿತ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಒಂದು ವೇಳೆ ಮೋಸ ಮಾಡಿ ಆದೇಶ ಪಡೆದಿದ್ದಲ್ಲಿ ಕಾಲಮಿತಿಯ ಅನ್ವಯವಾಗುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದ್ದು, ಅದರ ಬಗ್ಗೆ ಯಾವುದೇ ಭಿನ್ನಾಭಿಪ್ರಾಯ ಇಲ್ಲ. ಆದರೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಮತ್ತು ಪಚ್ಚಮ್ಮರವರು ಹೆಬ್ಬಟ್ಟಿನ ಗುರುತನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ಸಿವಿಲ್ ಮತ್ತು ಕ್ರಿಮಿನಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರುಜುವಾತು ಆಗಿರುವುದಿಲ್ಲ. ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಮತ್ತು ಪಚ್ಚಮ್ಮ ಇವರು ದಿನಾಂಕ 6/1/2004 ಅರ್ಜಿಯಲ್ಲಿ ತಮ್ಮ ಕೌಟುಂಬಿಕ ಕಾರಣಗಳಿಗಾಗಿ ಪ್ರಶ್ನಿತ ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಲು ಪೂರ್ವಾನುಮತಿ ಕೋರಿ ಜಿಲ್ಲಾಧಿಕಾರಿ ಬೆಂಗಳೂರವರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಮೂಲಕ ವರದಿ ಪಡೆದು ವ್ಯವಸಾಯಕ್ಕೆ ಯೋಗ್ಯವಲ್ಲ ಎಂದು ಮನಗೊಂಡು ಸರ್ಕಾರಕ್ಕೆ ಪೂರ್ವಾನುಮತಿ ನೀಡಬಹುದೆಂದು ವರದಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಮತ್ತು ಪಚ್ಚಮ್ಮ ಇವರು 17/2/2004 ಪ್ರಮಾಣ ಪತ್ರ ಸಹ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಒಂದು ವೇಳೆ ಪರವಾನಗಿ ಅರ್ಜಿ ಸಹಿ ಹಾಕದಿದ್ದರೆ ಅಫಿಡವಿಟ್ ಮಾಡುವ ಪ್ರಮೇಯ ಬರುತ್ತಿರಲಿಲ್ಲ ಮತ್ತು ಅವರು ಅಫಿಡವಿಟ್ ಮಾಡಲು ನಿರಾಕರಿಸಬಹುದಾಗಿತ್ತು. ಇಲ್ಲಿ ಗಮನಿಸಬೇಕಾದ ಇನ್ನೊಂದು ಸಂಗತಿ ಏನೆಂದರೆ, ಪ್ರಶ್ನಿತ ಜಮೀನು ಮಾರಾಟ ಮಾಡಲು ಸರ್ಕಾರವು ಅನುಮತಿ ನೀಡಿದ ನಂತರ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ PTCL ಕಾಯ್ದೆಯಡಿ ಪ್ರಕರಣ ಕೈಗೊಳ್ಳಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಒಂದು ವೇಳೆ PTCL ಕಾಯ್ದೆಯಡಿ ಪ್ರಕರಣ ದಾಖಲಿಸಬಹುದಾದರೂ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಆದೇಶದ ಮೇಲೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮೇಲ್ಮನವಿ ಪ್ರಾಧಿಕಾರವಾಗಿದ್ದು, ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ತಮ್ಮ ಕಾರ್ಯ ವ್ಯಾಪ್ತಿಯನ್ನು ಮೀರಿ ಪ್ರಕರಣ ದಾಖಲಿಸಿ ಆದೇಶ ಮಾಡಿದ್ದು ನಿಯಮ ಬಾಹಿರವಾಗಿದೆ. ಆದುದರಿಂದ ಶ್ರೀ ಕೆ ವಿಜಯಕುಮಾರ್ ಹೂ ಇಸ್ ಅ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮತ್ತು ಶ್ರೀಮತಿ ಗೋವಿಂದಮ್ಮ, ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ, ಶ್ರೀ ರಾಜಪ್ಪ ಮತ್ತು ಶ್ರೀಮತಿ ರುಕ್ಮಮ್ಮ ಅವರವರು ವಕೀಲರ ವಾದ ವಿವಾದವನ್ನು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳ ಗೌರವಾನ್ವಿತ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಮತ್ತು ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಮತ್ತು ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯಗಳ ಆದೇಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಮತ್ತು ಪಚ್ಚಮ್ಮ ಇವರು ತಮ್ಮ ಹೆಬ್ಬಟ್ಟಿನ ಗುರುತವನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ವರ್ತೂರು ಹೋಬಳಿ ಮುನ್ನೇಕೊಳಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 43/3 2 ಎಕರೆ ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಲು ಪೂರ್ವಾನುಮತಿ ಪಡೆದುಕೊಂಡು ನಂತರ ಖುದ್ದು ಹಾಜರಾಗಿ ಕ್ರಯಪತ್ರ ನೋಂದಣಿ ಮಾಡಿಕೊಡುವ ಮುನ್ನ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗಾಗಲಿ ಸರ್ಕಾರಕ್ಕಾಗಲಿ ತಕರಾರು ಸಲ್ಲಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಮೂಲ ಮಂಜೂರಾತಿದಾರರು ವಾರಸುದಾರರು ಖುದ್ದು ಹಾಜರಾಗಿ ನೋಂದಣಿ ಮಾಡಿರುವುದರಿಂದ ಕಂಡು ಬರುತ್ತದೆ. ಹಾಗೂ ಫೋರ್ಜರಿ ಮಾಡಿರುವ ಕುರಿತು ಯಾವುದೇ ಸಿವಿಲ್ ಅಥವಾ ಕ್ರಿಮಿನಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಶ್ನಿಸುವುದು ಕಂಡು ಬರುವುದಿಲ್ಲ ಮತ್ತು ಫೋರ್ಜರಿ ಮಾಡಿರುವುದು ಕುರಿತು ಯಾವುದೇ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ರುಜುವಾತು ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ವಿಕ್ರಯವಾದ ನಂತರ ಸರ್ಕಾರವು ನೀಡಿದ ಪೂರ್ವಾನುಮತಿಯನ್ನು ರದ್ದುಪಡಿಸಲು ಸಕಾರಣಗಳು ಇರುವುದಿಲ್ಲ. ಸರ್ಕಾರಕ್ಕೆ ಫೋರ್ಜರಿ ಮಾಡಿರುವ ದಾಖಲೆಗಳ ಕುರಿತು ನಿರ್ಣಯ ತೆಗೆದುಕೊಳ್ಳುವ ಅಧಿಕಾರವಿರುವುದಿಲ್ಲ. ಸರ್ಕಾರವು ಪ್ರಶ್ನಿತ ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಲು ನಿಯಮಾನುಸಾರ.
Now, how that state will decide that whether it is a forgery or documents as tampered and all? How can that be decided?
Government cannot decide as your lordship proceed because the civil court can do it. But as it was directed by this court, what the court should have done it, the government should have done it, that evaluated, they should not have sustained the order of the DC. They should have said, keep the matters as they are, we will reconsider or advise the parties to go to a civil court. That aspect is not considered by the government. Once for all, on the basis of this, they could not foreclose.
No, they said if it is in a forgery, either you have not go to the civil court or not complained, then presumption is it's you have given an opinion for that. Therefore, they have considered that. You could have approached that court, civil court, and seek for a stay of this order.
Yes, your lordship, I would have gone, but the proceedings are before the authorities. Before that authorities can suppose give a relief, going to a civil court would not arise. Your lordship has to consider this. Government should have kept the matter pending, advised the parties to go before a civil court so that the question of forgery.
See, High Court direction is there.
Yes.
You could have, in that High Court direction, you could have said that the matter can be, see, this court has not, nobody has brought to the notice of the court saying that this is a disputed facts
No, no,
regarding-
it is all before the court, your lordship.
And then how can that?
All these facts are before the court.
Hmm.
The court felt, your lordship, government should take a decision on these things.
How can they take a decision in respect of
Your
forgery
lordship-
and all?
Your lordship has to appreciate, it is the direction of this court by which we went before the government. Either the government should have said, this we can't do it, you go before the civil court, or they should have. They have not done it, but they are trying to foreclose our remedies. That is where we are stuck, your lordship. If the government gives an opinion like this, then your lordship will kindly say, our remedy.
We'll clarify that this will not come in the way of you to approach that
No,
civil
on
court.
on the other hand, my submission would be, your lordship. Your lordship may remand the matter to the government. Consider the matter in view of the views expressed by this court, and then take a decision. All that I pray, your lordship, remand the matter so that we can bring to the notice of the court, what is the views of this court, why it was remanded, and then.
Yes, mister. Yes, next week.
Next week, because I may not be here in 2:30, therefore, next week.
Next week, yes. Please this matter next week.
Date you will fix.
Next week ಅಂದ್ರೆ next Wednesday ಬರುತ್ತೆ.
ಆಗ್ಬೋದು.
29th ಆಗ್ಬೋದು, next day ಆಗ್ಬೋದು, 29th ಆಗ್ಬೋದು. Thursday, ಬುಧವಾರ ಬಂದು next.
Thursday, or we'll have it on third.
Third, your lordship may have it.
Yes, third.
Interim order to be extended.
Interim order granted earlier is extended. Yes, he is doing good. Yes, how many years you have put in practice?
20 years of practice.
Yes. Yes.
Much obliged.
Till number 64, R. Shashidhara for appellant, connected matter, B.S. Umesh.
So online, Umesh idhara. Umesh, online.
Serial number?
My lord, I appear for the appellant in the connected matter. I have to take steps, my lord. I had filed application for paper publication. My lord said 3 times anta correct address verification ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀನಿ. I may be given about a week's time. I'll take steps. My appeal is on liability, my lord. My case is on fraud.
ಆಗಿಲ್ವಾ process?
ಇಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ.
Where is that application?
ತಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಇದ್ ಮಾಡಿದ್ರಿ ಬೇಡ 3
ಆಯ್ತು,
ಟೈಮ್ಸ್
3 ಸರಿ ಆಯ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅದಕ್ಕೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ. ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ವೆರಿಫಿಕೇಶನ್ ಕಳಿಸಿದ್ದೆ. ವೀಕ್ಸ್ ಟೈಮ್ ಕೈಂಡ್ಲಿ ಬಿ ಗ್ರಾಂಟ್. ಅಪ್ಲಿಕೇಶನ್ ತಾವು ಇದ್ ಮಾಡಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿ 3 ಟೈಮ್ಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರಿ.
R1 expert before the trial court. They're questioning that, my lord. They're questioning my lord, the involvement of the vehicle.
Yes.
And the injuries sustained by the appellant herein in the said accident, my lord. If their case is, my lord, considered, no liability is fixed against the owner, my lords. Before the trial court, the owner is ex parte. Yes, my lords, they can seek for dispensation or notice instead of taking the steps, my lord.
My lord, if the liability goes on the owner.
If he succeeds, the claim petition will be dismissed. No question of pain required ಬರೋದಿಲ್ಲ ಕೇಸಲ್ಲಿ.
My lord, fraud ಅಲ್ಲಿ there is a division bench ruling.
ಹೌದು ಸ್ವಾಮಿ, fraud ಆಗಿದ್ರು.
Yes, Mr. Umesh, what is that your grievance?
My lord, false implication of the vehicle.
No, on what ground you are challenging that award?
My lord, false implication of the vehicle, my lord.
Vehicle is.
Yes, my lord, that is what I, and my lord, there is no MLC, my lord. The doctor who says, once he says there is MLC, I will produce it, and subsequently they don't produce. In fact, this was heard for some time, and then, my lord, I was permitted to take steps.
Owner, my lord, owner is not necessary, my lord. Since he is already placed ex parte.
My lord, it is my appeal.
We also will place ex parte, my lord.
No, that you can file an application under order of 41 rule 33.
Yes.
Please, but I'll do that. If that is the, in fact, paper publication order ಮಾಡಿದ್ರೆ ಅಯ್ಯೇ ಇದೆ ನಾನು I will take steps. ಮುಗಿಸೇ ಬಿಡಬಹುದು.
Paper publication not necessary.
ಅಯ್ಯೇ ಇದೆ ಸ್ವಾಮಿ.
It saves money and time also.
Sir, no problem, sir. It is my money. The company's money.
Yes, learned counsel for the appellant in MFA 1223 of 2019. Press weeks time to file application for paper publication.
It's already there, Milan.
Substituted service. Yes. You file an application for substituted service by next
Milan,
week.
Milan, there was an application. Milan said 3 times ಆಗ್ಬೇಕು ಅಂತ. That is how the.
ಎಲ್ಲಿದೆ application?
Milan, it is filed on.
ಎಲ್ಲಿದೆ application?
They have not filed application.
Not yet filed, mister.
And it was posted.
No application is filed.
I'll about
Yes.
weeks time.
Weeks time to file necessary application for substituted service of notice to
Next
R
one.
to.
Next
This
Wednesday.
matter next week. Yes.
Please, public.
Eight. Come on. 16. ವಾಸವ್ರು 2 ಸಲ ಕರೆದ್ವಲ್ಲ. ವಾಸವ್ರಲ್ಲೇ ಇದೆ, ಯಾರು ಬರ್ಲಿಲ್ಲ. 2 ಸಲ ಆಯ್ತು. ಅವರು ಒಂದು ರೌಂಡ್ ಕೊಟ್ಟು ಹೋಗಿದ್ದಾರೆ, ಅದ್ರಲ್ಲಿದ್ರೆ ಮಾಡ್ಬಿಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಮಾಡಬೇಡಿ ಅಂತ.
ಸ್ಟೇಟ್ ಎಲ್ಲ ಅಜ್ಜನ್
1 week. ಹಾ 1 week. 1 week. ಫಿಗರ್ ಹೇಳಿಲ್ಲ ಸರ್, ಏನೋ ಗ್ರೌಂಡ್ಸ್ ಹೇಳಿದ್ರು ಅಷ್ಟೇ. ಸಾಹೇಬ್ರು ಅದಕ್ಕೆ ಅಷ್ಟರಲ್ಲಿ ಬಂದ್ರೆ ಮಾಡೋಣ, ಇಲ್ಲ ಅಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಪೇಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರು ಕೊನೆಗೆ. ತಿರ್ಗಾ ಸಾಹೇಬ್ರು ಅಷ್ಟಾದ್ರೆ ಮಾಡ್ಬೋದಲ್ವಾ, ಹಾಗಾದ್ರೆ ಮಾಡಿ. ಎಲ್ಲ 2 ರೌಂಡ್ ಆಗಿದೆ ಮೇಡಮ್ ಇಲ್ಲಿವರೆಗೂ, ಅಪ್ ಟು ಎಂಡ್ 2 times ಆಗಿದೆ. ಯಾವುದು 22 ನಾ 21 ಅಮ್ಮ ನಿಮ್ದು? ಯಾರು ಅಡ್ವೊಕೇಟು? ಎಂ ಜೋಸಫ್ ಅಂತ ಯಾರು ಇಲ್ಲ ಅಲ್ಲಿ. ಜೋಸಫ್ ಅನಿಲ್ ಕುಮಾರ್ ಅಂತಿದೆ. 2 weeks. 2 ಸಲ ಕಾಲ್ ಔಟ್ ಆಗಿದೆ. ಅದು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಕರೆದಿದ ತಕ್ಷಣ ಅದು ಎವಾಪರೇಟ್ ಆಗುತ್ತೆ, ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ರಿಫ್ಲೆಕ್ಟ್. ವಾಚ್ ಮಾಡ್ತಾ ಇರ್ಬೇಕು ನೀವು.
Yes.
ಇಲ್ಲ ಒಂದು ಸೆಕೆಂಡ್ ತಿಳ್ಕೊಳ್ಳಿ, ನಿಮಗೆ ವೇಟಿಂಗ್. ಸ್ವಲ್ಪ ಏರ್ ಮಾಡಿದ್ರು, ಆಮೇಲೆ ಅವರೇ ಬರ್ಲಿ, ಅವರೇ ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿ ಅಂದ್ರು. ಎರಡನೇ ನಿಮ್ದೆ ಕೇಳ್ಕೊಡಿ. First over matter, serial number 9, Sandhya D for petitioner.
Yes.
ಇಲ್ಲ sir. Serial number 9, Sandhya D.
ಏನಾಗಿದೆ? ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? None appear for the petitioner. Reach this matter after 2 weeks.
Serial number 10, FS Dabali for appellant, connected matter, Shripad V. Shastri.
I approve for the appellant.
Yes.
Appear for the appellant, madam.
Your murder.
Yes.
We have challenged, my lord, the apportionment of liability between the KSRTC and owner and insurer of lorry.
Yes.
Because in connected cases, not 50% has been apportioned. But in the instant case, not 75% has been fixed on the KSRTC.
No, that you also filed an insurance company is also filed in respect of it.
In connected matters, not a 50% apportionment has been there. On that ground, not we have filed this stuff.
Yes, how that accident has occurred, Mr.
Because in the
No, there you are contesting that matter on that.
The bus has dashed against the rear portion of the lorry.
Yes. You, one of them is argued, then other can give a reply.
Yes.
You can argue, Mr. Dabali, that
in 10.3 model in Redka case, till not the response has not been served.
Yadrali?
10.3 model Redka case.
Yadrali, our case alla?
737 but 2018.
ನಮ್ದು KSRTC ಏನು
You take notice.
Climates appeal.
ಅಲ್ಲ ನಿಮ್ದಲ್ರಿ
ಅದ್ರಲ್ಲಿ ಯಾರು?
ಅದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ಇನ್ನೂ ಜಾರಿ ಆದಂಗೆ ಕಾಣಲ್ಲ. ರೆಸ್ಪಾಂಡ್ ಮೋಡ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಸರ್ವ್ಡ್.
No, which respondent?
ಅದು ಥರ್ಡ್ ರೆಸ್ಪಾಂಡ್ ಇದೆ ಪ್ರೊಸೆಸ್ ಇದೆ.
ಯಾವ ಕೇಸಲ್ಲಿ ನೀವು
10.3 ಮಾಡಿದ ರೆನ್ಕಾಸ್ ಕೇಸ್.
ಅದಾಯ್ತು, ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಯ್ತು ಬೆಳಿಗ್ಗೆ.
ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮಾಡಿಸಿದ್ದಾರೆ 2738.
If dispense mode, then apportionment of liability they can't challenge madam.
Why?
Because owner is KSRTC is a party in that case.
No, see, apportionment, if it is held that 100% their insurance company, they have to pay it. Why that owner has to come? It's covered by insurance policy. See, if there is no insurance policy, owner liability will come.
ಅಲ್ಲ ಓನರ್ ಪ್ರಶ್ನೆ ಅಲ್ಲ, ಅದು ಕಾರ್ಪೊರೇಷನ್ ಜಾರಿ ಆದಂಗೆ ಕಾಣಲ್ಲ. ಅದು ಕಾರ್ಪೊರೇಷನ್ ಮಲೋಡ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಸರ್ವ್ಡ್.
ನಿಮಗೆ ಸರ್ವ್ ಆಗಿಲ್ವಾ ನೋಟಿಸ್ ಅದರಲ್ಲಿ?
ಇಲ್ಲ.
ಎಲ್ಲಿದೆ ಅವ್ರು ಕೊಡಿ, ಅವ್ರು ಫೈಲ್ ಕೊಡಿ. 2798.
10.3.
2798 ಕೊಡಿ.
R3 ಯಾರು ಸರ್? ಅದು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
KSRTC ಮಾಡಕ್ ಬರಲ್ಲ, ಇವ್ರು ಇದಾರಲ್ಲ ಇಲ್ಲೇ. ಡಿವಿಷನಲ್ ಕಮಿಷನರ್ ನಾರ್ತ್ ಈಸ್ಟ್ ಕರ್ನಾಟಕ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಕಾರ್ಪೊರೇಷನ್ R2 ಏನಾಗಿದೆ?
ಸರ್ವ್ ಆಗಿದೆ.
R2 ಯಾಕೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿಸಿದ್ರಿ? ಹೆಂಗ ಇವ್ರು ಇದಾರಲ್ಲ.
ನಾನ್ ಮಾಡ್ಸಿಲ್ಲ ಸ್ವಾಮಿ, ನಾನ್ ಮಾಡ್ಸಿಲ್ಲ, ಇವ್ರು ಮಾಡ್ಸಿರೋದು.
By order dated 21/12/2018 notice to R2 dispensed ಏನೈತ್ರಿ?
ಇಲ್ಲ, ಇವ್ರ ಕೇಸಲ್ಲಿ ಆಗಿರೋದು, ಇವ್ರದ್ದು ಮೆಲಾಡ್ ಶ್ರೀಪಾ ಶಾಸ್ತ್ರಿ ಅವ್ರ ಕೇಸಲ್ಲಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್. ನಾನ್ ಪ್ರೋಸೆಸ್ ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ನಾನ್ PF ಕಟ್ಟಿ.
We'll see order dated 21/12/2018.
ಪ್ರಾಬ್ಲಿ ಅವ್ರ ಕೇಸ್ನಲ್ಲಿ ಮಾಡಿದ್ ನನಗ್ ಬಂದ್ಬಿಟ್ಟಿದೆ, ಯಾಕಂದ್ರೆ ನಾನಂತೂ PF ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Learned counsel for the appellant in MFA 2798. 6 weeks time to furnish the deficit post. Learned counsel for the appellant MFA 73. Dispense notice to R2. Memo to already 737 ಗೆ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿರೋದು. ಇದಕ್ಕೆ ಡಿಸ್ಪೆನ್ಸ್ ಅಂತ ಬರೀತಾರೆ.
ಇದಕ್ಕೆ ಬರೆದು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇದ್ರದ್ದು ಅದಕ್ಕೆ ಅದು ಇದಕ್ಕೆ ಬರ್ತದೆ. See yours now what has happened, notice ಸರ್ವ್ ಆಗಿತ್ತ ನೋಡ್ರಿ R2 ಗೆ
2798 ಅಲ್ಲಿ
R2 ನೋಟಿಸ್ ಏನಾಗಿದೆ? ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿಸಿರೋದು ಇವ್ರದ್ರಲ್ಲಿ R2 is served unrepresented, Mr.
ರೆಸ್ಪಾಂಡ್ ಕಾರ್ಪೊರೇಷನ್ ಮಾಡು.
Corporation. You will take notice. Yes. ಇದರಲ್ಲಿ
ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋದು
10.3 ಅಲ್ಲಿ ಶ್ರೀ FS Depali is undertake to appear for respondent number
2 ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ. 2 ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ.
ಡಿಸ್ಪೆನ್ಸ್ ಇಲ್ಲ ಆಗಿಲ್ಲ, ಅದು ರಾಂಗ್ ಆಗಿ ಎಂಟ್ರಿ ಆಗಿದೆ. ಏನಾಗಿದೆ ಗೊತ್ತಾ? 10.2 ಅಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ 2ಗೆ. R1 is served ಅಂತ ಇದೆಯಲ್ಲ, ಅದು ಇಲ್ಲಿ ತೋರಿಸ್ಬೇಕಿತ್ತು. ಅದು ಉಲ್ಟಾ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ, ಅವೆಲ್ಲ ನಮ್ಮ ಆಫೀಸ್ ಮಿಸ್ಟೇಕ್.
2798
where there is no pedestrian crossing, because this is not a national highway notes and there is no marking at all.
Now that you take notice, will
in 2798 ನೋಡು.
2798. Yes.
2798 ಅಲ್ಲಿ ಅವರು ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿಸ್ತಿರಲ್ಲ. ರೇಣುಕಾ ಮೇಡಮ್ 2798
ಮಾಡ್ಸಿಲ್ರಿ, ಅದ್ ತಪ್ಪಾಗಿ ಆರ್ಡರ್ ಬರ್ದಿರಿ. ನಮ್ಮ ಆಫೀಸ್ನವ್ರು ಏನ್ ಬೇಕಾದ್ರೆ ಬರೀತಾರ್ರಿ, ಸತ್ತೋಗ್ದಿಲ್ದಾರ್ನು ಸತ್ತಾರಂತ ಬರೀತಾರೆ. This is order is court has specifically passed an order in 737 saying that it is dispensed. They have written here is as in dispensed. ಹೇಳ್ತಾ ಇದೀನಿ ಅವಾಗ್ಲಿಂದ. Yes. So and so is directed to take notice for respondent number 2. Respondent number 3 is managing partner, that will dispense, madam.
Yes, ಅದ್ ಬೆಳಿಗ್ಗೆ ಆರ್ಡರ್ ಆಗಿದೆ.
Yes.
ಬಿಕಾಸ್ in 1 and 2 ಅದ್ರಲ್ಲೂ ನನಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಅಂತ ನಾನು ತಮ್ಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡೆ. 10 point ಅಲ್ಲಿ 1 ನಲ್ಲಿ 2 ನಲ್ಲಿ ಸಿನ್ಸ್ ದೇ ಹ್ಯಾವ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಅಂಡ್ ಅದ್ ತಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀರಾ ಬೆಳಿಗ್ಗೆ?
Yes. In respect of respondent number 3, in connected matter, it is served unrepresented.
Yes.
Hence, she sought for dispensation of notice to R3. Notice to R3 is dispensed. Now it is complete. ಇದರಲ್ಲಿ ಶಾಸ್ತ್ರಿ ಅವ್ರ ಕೇಸಲ್ಲಿ ಕಾರ್ಪೊರೇಷನ್ ಏನಾಗಿದೆ ಕೊಡಿ.
ಶಾಸ್ತ್ರಿ ಕೇಸಲ್ಲಿ ನಾವು ಅಪೀಲ್ ಆಗ್ತದೆ. ಶಾಸ್ತ್ರಿ ಕೇಸಲ್ಲಿ ಐ ಅಪೀಲ್ ಮಾಡಿ ಫಾರ್ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಒಂದಲ್ಲ, ಇವ್ರದ್ದು ತಿಪ್ಪೇಸ್ವಾಮಿ.
ಆಮೇಲೆ ನನ್ ಕೇಸಲ್ಲಿ ತಿಪ್ಪೇಸ್ವಾಮಿ NOC ಅಂತಿದೆ ಸ್ವಾಮಿ, ಅದು ತೆಗಿಬೇಕದು. ಬಿಕಾಸ್ ನನಗೆ ಕನ್ಫ್ಯೂಷನ್ ಆಗೋಯ್ತು, ನಾನು ಯಾವಾಗ NOC ಕೊಟ್ಟೆ ಅಂತ.
ಹೌದು,
ಶಿವಪ್ರಶಾಸ್ತ್ರಿ ಸರ್ ಕಡೆಯಿಂದ ನಮಗೆ ನೋಟ್ಸ್ ಬಂದಿದೆ.
ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಅದರಲ್ಲಿ? This is all that mistake the office is making. Yes. ಒಂದಾಯ್ತು. ಇದರಲ್ಲಿ ಶಾಸ್ತ್ರಿ ಇದು ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ನೀವು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು.
737 ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಸರ್, ಅದರಲ್ಲಿ ಶಿವಪ್ರಶಾಸ್ತ್ರಿ ಅವರು ನಾನೀಗ 737 ಅಲ್ಲಿ ನನಗೆ ನೋಟ್ಸ್ ಬಂದಿದೆ.
737 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ regional manager, national insurance company, BC Sitaram is appearing or you are appearing, madam?
ನನ್ಗೆ ಕೊಡ್ತಾರೆ ಯೂಶಲಿ, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದ್ರೆ ಬೇರೆಯವ್ರಿಗೆ ಕೊಡೋದಿಲ್ಲ.
ಅದ್ರಲ್ಲಿ I will directed to show your name.
Yes madam. Yes madam.
ಅದರಲ್ಲಿ 737 ಅಲ್ಲಿ office is directed to delete the name of BC Sitaram Rao for R3. Show the name of Renuka HR. ಆಮೇಲೆ
ಅದರಲ್ಲಿ
ಒಂದು R1 ಗೆ ಏನಾಗಿದೆ ಅದರಲ್ಲಿ ಸರ್ವ respondent number 1 is served unrepresented. FS double is directed to take notice is undertaken to appear for R1. R2 ಗೆ ಏನಾಗಿದೆ ಡಿಸ್ಪೆನ್ಸ್ ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ ಆಯ್ತಾ. ಇನ್ನ 10.1 ನಲ್ಲಿ 10.1 ನಲ್ಲಿ ಕೊಡಿ. 10.1 ನಲ್ಲಿ ದಬಾಳಿ ಅವರು ಹಾಕಿದ್ದಾರೆ. ವಕಾಲತ್ is not filed. First matter ಅಲ್ಲಿ service is completed. Now it is complete. Ready or you want time?
10.1 ಮಾಡಿದ್ರೆ common, one by the corporation, one by the.
10.1 ಅಲ್ಲಿ again BC Sitaram name has to be deleted. Show the name of Renuka HR. FS Dabali for R1, R2 dispensed, R3
Served unrepresented.
Yes.
ಅದರಲ್ಲಿ ಶಿವಪಾಶಾಸ್ತ್ರಿ ಹೆಸರು ಅದು ಸ್ವಲ್ಪ ಡಿಲೀಟ್ ಮಾಡಿ
ಅದರಲ್ಲೂ ನೀವೇನಿದ್ದೀರಾ?
ಅದು 10/12 737/18 ಅಲ್ಲಿ.
ಹಾಗಾದ್ರೆ ಶಾಸ್ತ್ರಿ ಯಾವ ಕೇಸಲ್ಲೂ ಇಲ್ಲ.
ಫಸ್ಟ್ ಕೇಸ್
ಅದು ಒಂದೇ ಫಸ್ಟ್ ಕೇಸ್ ಹೇಳಿದ್ರು. ಸೆಕೆಂಡ್ ಕೇಸ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು ಇದೆ. ಸೆಕೆಂಡ್ ಅಂಡ್ ಇದ್ರಲ್ಲಿ ಇದೆ. ಇದರಲ್ಲಿ ಥರ್ಡ್ ಕೇಸ್ ಅಲ್ಲಿ ಆಫೀಸ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ 10.3 ಅಲ್ಲಿ ಶ್ರೀಪಾದ್ ಶಾಸ್ತ್ರಿ ಫಾರ್ R1. Show the name of BC Tippeswamy. Now that service is complete. Yes, Mr. You are ready or you want time?
Some time.
You want time? Yes, he wants time. Yes. Yes, at the request of counsel for appellant in MFA 3868 of 2017. Please this matter next week. Yes.
Serial number 11.
Date fix now. Any date?
3rd September. Yes.
3rd September.
Second respondent in this case.
Serial number 11, BM Siddhappa for appellant, Ravish Penny.
Yes.
Well, it is not a case for enhancement, please, my lord. For this reason, kindly come to the para 20 and 21, please.
He was there in that morning. Yes. What is this, Mr.
Injury case, sir. The fracture of both the bones of the right forearm. And fracture of the 2 to 7th rib. So he was bus owner and
liability and dispute illa.
Liability is not dispute.
Yes. What is that income they have assessed? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಇಲ್ಲ ಅವ್ರಿಗೆ ಅವರು they said 80,000. But he produced the document to show that income was increased after the date of the accident.
Tribunal ಏನ್ ಮಾಡಿದ್ದಾರೆ? Disability.
Disability ಅದಿಲ್ಲ. He is not a treated doctor. ಹಿಂಗಾಗಿ ತಗೊಂಡಿಲ್ಲ ಅವರು.
Disability ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. 35% ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್. Because he is not a treated doctor ಅಂತ ಕೊಟ್ಟಿಲ್ಲ. ಒಂದು his income has been increased from the date of the accident thereafter, please. Para 21, para 20, please.
Para 20.
Please.
Yes, read.
He's further PW states that prior to the accident, he was hale and healthy and was owner of the bus, owner of the cashier mission, and owner of the agriculturist, and earning rupee 80,000. Subsequent to that, the producer so and so wherein shows that petitioner has obtained the license from the government from the evidence for PW1. It is quite clear that even now petitioner working as before and getting the income. Further, he admitted that in the cross-examination, fact that his income tax returns has been subsequently 2015 has been increased. Even now, he is growing the arconet in his land and getting the income. As such, there is no loss of earning above this disability suffers from the petitioner, nothing to do with his earning capacity of the petitioner. Para 21, please, madam. Counsel for the petitioner relying upon the judgment of the so and so. Further, RIPS so and so, it is taken into consideration, but in the said case, petitioner is a laborer and citation submit kotarala aa case alli laborer hinಗಾಗಿ ತಗೊಂಡಿದ್ದಾರೆ. But in the instant case, petitioner is not a laborer, but is the owner of the bus businessman. As such, in view of the above reasonings, material and record, said ruling is not applicable to the facts and nevertheless the said disability.
Pain and suffering ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಆಮೇಲೆ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ದ ಲೇಟರ್ ಪೀರಿಯಡ್ ಏನಿಲ್ಲ.
ಲಾರ್ಡ್ಶಿಪ್ ಅಲ್ಲಿ 35% ಡಿಸೆಬಿಲಿಟಿ ಇದೆ.
ಬಟ್ ದೇರ್ ಇಸ್ ನೋ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್.
80,000 ತಗೊಂಡಿದ್ದಾರೆ. ಎಲ್ಲೂನು ಇವರು ಏನು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ. ಅದು 80% ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಅಂತ ಇವ್ರು ಏನು ಕ್ವಶನ್ ಮಾಡಿಲ್ಲ, ಇವ್ರು ಏನು ಇದ್ ಮಾಡಿಲ್ಲ. ಸೊ TCR ಬಂದ್ರೆ ತಮಗೂ ಗೊತ್ತಾಗುತ್ತೆ ಹೆಂಗೆ ಅನ್ಬಿಟ್ಟು. TCR call for ಮಾಡಿಲ್ಲ ಅಲ್ಲ.
What is the point you are canvassing now?
The disability has not been considered, Lordship. Disability ground should be considered.
No, disability is not considered because you have admitted in that class examination, my income has been increased.
The cross exam, but they have not at all questioned.
Our question ಮಾಡೋದು ಯಾಕೆ ಮಾಡ್ತಾರೆ? See, what is wrong in that finding of the tribunal? Your income has been increased, then you are not entitled for that. Only thing is that your income is reduced because of that injury, disability, then that has to be compensated.
We have to pay the compensation for reduction of compensation.
But in respect of that disability you have suffered, that for an amenities is concerned, you are entitled.
Immunities 70,000 ಕೊಟ್ಟಾರ ಸರ್.
ಸ್ವಲ್ಪ
Pain and suffering nothing.
ಅದು ಕಡಿಮೆ ಐತ್ರಿ.
ಎಲ್ಲಿ ಕೊಟ್ಟಾರೆ?
15,000 ಕೊಟ್ಟಾರ.
15,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಮೇಲೆ
loss of income during the later period ಇಲ್ಲ.
ಅದು ಕೊಟ್ಟಿಲ್ಲ. ಆಮೇಲೆ ನ್ಯೂಟ್ರಿಷಿಯಸ್ ಫುಡ್ ಮಿಸ್ಲೇನಿಯಸ್ ಎಕ್ಸ್ಪೆನ್ಸ್ 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಮಾರ್ಜಿನಲ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಇದೆ, ಬಟ್ ಅಮ್ಯುನಿಟೀಸ್ ಗೆ 70,000 ಕೊಟ್ಟಾರೆ.
ಮತ್ತೆ ಅಮ್ಯುನಿಟೀಸ್ ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ.
ಅಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಡಿನೈಂಗ್, ಐ ಆಮ್ ನಾಟ್ ಡಿನೈಂಗ್.
Because
Suffered
he is
the
not
injury.
entitled for loss of
Some
income.
marginal enhancement is there.
Pain and suffering also.
Pain and suffering ಒಂದು 50,000, ಇನ್ನೊಂದು 75,000 ಕೊಡ್ಬೋದು.
Please.
Yes, mister.
Lordship, disability ಅವ್ರು 80,000 ತಗೊಂಡಿದ 80,000 ಅಂತ ಹೇಳ್ತಾರೆ. ನಾವು RTC ಎಲ್ಲ ನಾವು ಕೊಟ್ಟಿದೀವಿ.
No, you are not understanding what we are telling. You are not disputing your income at all. 80,000 or 1 lakh. You are admitted that there is no loss of income. That you have to show first. You have suffered a loss due to the disability. Then we can.
Because he states that he is the owner of, he is an agriculturist. He was an agriculturist. So he in paragraph number 20, he is an agriculturist.
Better let the records come, please. Yes, admit.
Delay condone.
Yes, delay of 65 days condone. How to admit? Yes.
Serial number 12, Nagaraj Hegde for appellant.
Second respondent.
Yes.
Case of injury, my lord. He was a coolie, my lord, aged about 37 years. The accident was occurred on 21/6/2017. And
Yes.
we have claimed, my lord, 15,000 salary per month. Tribunal has taken 9,000. And so far as disability is concerned, my lord, 20% disability has been assessed for the fracture, femur fracture, my lord. Fundal bone fracture, and the tribunal has taken 10%.
Early the discussion. Yes, para 22.
Para 20.
Read.
The evidence of the doctor PW2 goes to show that the petitioner having 20%.
20% 10 ತಗೊಂಡಿದ್ದಾರೆ.
10 ತಗೊಂಡಿದ್ದಾರೆ.
1/3 ತಗೋಗ್ರಿ, 10 ತಗೊಂಡಿದ್ದಾರೆ. You are not in appeal.
Yes. 2017 ಎಷ್ಟಿದೆ?
11,000.
11,000.
11,000, 10% into 12 into 50.
How many days you are in that hospital?
10 days. Loss of amenities ಗೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
Yes, ನೋಡೋಣ. Pain and suffering, medical expenses has been given. Future medical expenses has been given.
Loss of during the late period ಗೆ ಸರ್ ಅದು ಎರಡು ಹೆಡ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದರಲ್ಲಿ 10 days ಒಂದು 3 ತಿಂಗಳಿಗೆ ಒಂದು.
Loss of bed rest.
ಅದು 10 days ಗೆ ಪ್ಲಸ್ 3 ತಿಂಗಳದ್ದು ಕೊಡಿ. ಎರಡು ಸೇರಿ ಬೆಡ್ ರೆಸ್ಟ್ ಮಾಡಿಸಿ. ಲಾಸ್ ಆಫ್ ಡ್ಯೂರಿಂಗ್ ದ ಲೇಟ್ ಪೀರಿಯಡ್ ಅಂತ ಹೇಳಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ while reassessing the compensation for 3 months.
Loss of bed rest ಗೆ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ
10,000 ಅದಕ್ಕೆ 10,000 ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪ್ಲಸ್ ಲಾಸ್ ಆಫ್ ಡ್ಯೂರಿಂಗ್ ಲೇಟ್ ಪೀರಿಯಡ್ಗೂ ಕೊಟ್ಟಿ.
ಅದು 3,000 ಅಷ್ಟೇ.
ಅಲ್ಲ, ಟೋಟಲಿ ಅದನ್ನು ಲಾಸ್ ಆಫ್ ಡ್ಯೂರಿಂಗ್ ಲೇಟ್ ಪೀರಿಯಡ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ 3 ತಿಂಗಳಿಗೆ ಕೊಡು.
ಎಸ್.
ಆಮೇಲೆ ಲಾಸ್ ಆಫ್ ಇದು ಇನ್ಕಮ್ ಜಾಸ್ತಿ 11,000
ಚಾರ್ಜಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
ಅಮ್ಯುನಿಟೀಸ್ ಎಷ್ಟು ಗ್ರಾಂಟೆಡ್? ಎಸ್. ಇಂಟ್ರೆಸ್ಟ್ ಕರೆಕ್ಟ್ ಇದೆ.
Interest 6%.
So and so learned counsel appearing for claimant has contended that at the time of the accident he was earning 15,000 per month. Tribunal has considered that notional income of the claimant has 9,000 per month is on lower side. Secondly, he has contended that due to that accident claimant has suffered grievous injury. He was inpatient for a period of 10 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering. Loss of income during the later period. Other incidental expenses is on lawyer side. Tribunal has failed to grant any compensation for loss of amenities. Hence, he sought for enhancement of compensation. Per contra, the Binny Learned Council appearing for insurance company has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 9,000 per month. Secondly, he has contended that considering that evidence of doctor and injury suffered by the claimant and considering that medical records, the compensation awarded by the tribunal for pain and suffering and other incidental expenses are just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. Feroz, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 21/6/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA 47J4461. Due to that accident, claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disability is 10%. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Notional income has to be assessed as per the guidelines. 11,000 has to be considered. The multiplier applicable to that age group is 15. Accordingly, loss of future earning has been reassessed as follows.
11,000 into 12 into 15 into 10%, 1,98,000.
Yes. Due to that accident, claimant has suffered the aforesaid injury, was inpatient for a period of 10 days, suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for the claimant is entitled for loss of income during the later period for 3 months, loss of earning during the treatment and loss of bed rest together has to be granted for 3 months. And the claimant is also entitled for loss of income during the conveyances, nourishment, attendance charges has to be enhanced from 8,000 to 12,000. Loss of immunities, claimant is entitled for 40,000. Other head compensation awarded by the tribunal is just and reasonable. Accordingly, the appeal is allowed in part.
Serial number 16, Gopal Krishna N for appellant, connected matter B Latif, BC Shivanya Gowda.
Yes. Yes, Mr.
Sorry, my morning session we were not because other
Yes.
matters going on. This is the parted matter. The last occasion they have addressed the argument, it is for the replay. Your lordship has granted.
Why it is a fake license, sir?
Please.
You want to verify the judgment you took the time?
Please.
What is the judgment?
No, before that minute, I want to place some fact.
Yes.
Which was, I don't know whether they have placed it or not.
Yes.
But date of accident involvement of the vehicle is not in dispute.
Yes.
Only point for consideration is that Milad, exhibit P8, the replay was given by the owner of the vehicle, stating that some person was driving the vehicle Parkesh was driving the vehicle, his driving license number was mentioned in that 133 replay notice. Basing on that, my lord, I have summoned the document from the RTO. They say that it is not belongs to that borough, it is belong to some other person. Basing on that, my lord, I have filed the additional written statement before the court, stating that this is the number which was given to this is a fake one. Calling upon the owner to produce the original driving license. Owner has appeared and filed the written statement contending that his driver has having a driving license, but no document was placed before the court. We have placed the document basing on the 133 notice. 133 notice contains only the driving license number, not the driving license. They have not produced before the court a driving license. Therefore, my lord, it cannot be say that the driving license is a fake one. But the driver is not having a driving license. ಅವನೇನು ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಅವನ ಹೆಸರಲ್ಲಿ ಬರ್ಸ್ಕೊಂಡ್ ಬಂದ್ ಹಾಕಿದಾನೆ ಅಂತೇನು ಇಲ್ಲ. ಬಟ್ ಅವನ ಹೆಸರಲ್ಲಿ ಆ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ. That means he is not having a driving license. In so far as third party is concerned, my lord, I am liable to pay because of the.
No. See, there is a driving license number.
Please.
What is that number?
That is number, my lord, exhibit P8 in this. UP 212013001389.
Fake driving license exhibit ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಕೊಟ್ಟಿದೆ.
ಅಲ್ಲ, what is that exhibit in that? R3. Yes, exhibit R3 ಕೊಡಿ.
ಕೊಡಪ್ಪ. ಎಲ್ಲಿ ಕೊಡಿ? ಅಲ್ಲಿ ಕೊಡಿ.
ಎಲ್ಲಿದೆ ಮಾರ್ಕ್? ಇದೆ ರೆಕಾರ್ಡ್. ಅದ ಅವನು ಅವ್ರು ಹೇಳೋದು
ಅಲ್ಲಿ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಅದಿಲ್ಲ.
ಇವನ ಹೆಸರಲ್ಲಿ ನನಗೆ ಕೊಟ್ಟಿರೋದು ಅವನು. R3.
ನಿಮ್ಮ ಡ್ರೈವರ್ ಹೆಸರೇನು?
ನಮ್ಮ ಫಾರೂಕ್.
ಲೈಸೆನ್ಸ್ ಅನ್ನೋ ಮಷ್ಕೂರ್ ಅಂತ.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ.
It is not. Malad, they have produced before this court.
No. ಅದು ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ನಾನು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದು.
No, what is the name of the driver?
ಫಾರೂಕ್. ಫಾರೂಕ್.
R3 is not the extract of driving license of some lady.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ.
ಏನಿದೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ? ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಏನೂ ಇಲ್ಲ.
ಇಲ್ಲ ನನಗೆ
that R3 exhibit R3 has been produced. ಯಾರ್ದಿದು ಎಕ್ಸಿಬಿಟ್ R3?
ನನಗೆ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ ಇದೆ.
ನಾನು ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡಿದೆ, ಈಗ ಅದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಂಡು ನೋಡಿದ್ದೆ.
ಎಕ್ಸಿಬಿಟ್ R3 ಟೆಂಪರರಿ ಅಡ್ರೆಸ್, ಇಟ್ ಈಸ್ ಬಿಲಾಂಗ್ಸ್ ಟು ಸಮ್
ಸೆಪ್ಟೆಂಬರ್ 20.
ವಾಟ್ ಇಸ್ ಯುವರ್ ನೇಮ್? ಅನ್ನಂ ಮಾಸಕ್ಕೂರು
ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ. ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದರಲ್ಲಿ ಇದೆ.
ನೀವು ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಎ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
Yes, filed the return statement.
ನೋಡ್ರಿ R3 ಎಲ್ಲಿದೆ ಕೊಡಿ, ಅದ್ಯಾಕೆ
ನಾನು ಇಲ್ಲಿಂದ ತಗೊಂಡಿದ್ದೆ.
ಅದೇನ್ ಬರುತ್ತೆ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ?
This is produced there, but it is not marked there.
It is not
collectively marked ಅನ್ಸ್ತದಲ್ಲ?
ಕಲೆಕ್ಟಿವ್ಲಿ ಮಾರ್ಕ್.
Collectively.
It is not marked.
ಏನಂತ ಮಾಡಿ?
ಒರಿಜಿನಲ್ ಇಲ್ದೇನೆ ಹೆಂಗ್ ಮಾರ್ಕ್? ಸ್ವಾಮಿ, ಒರಿಜಿನಲ್ ಇಲ್ದೇನೆ DL ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ ಬರೋದೇ ಇಲ್ಲ, ಮಾರ್ಕ್ ಮಾಡಕ್ ಬರಲ್ಲ. Original is not before the court. How can they will mark that document?
No, we'll see his written statement.
Please, he says that para 9 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಡಿ ಸರ್.
Driving license.
Para 9 of the judgment, he says that I had a valid driving license, vehicle is having a permit and fitness, and my driver is having a driving license. But document was not placed.
No, this document is produced along with how this comes to the court records.
That is produced from their side, that RTO has been examined.
ಅಲ್ಲ, ಇದು ಆ ಫೇಕ್ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇದೆಯಲ್ಲ, how it comes to that court records? ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡೋ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
ಹಾಗೆ ಇವ್ರ ಕಡೆಯಿಂದ ಮಾಡಿದ್ದಾರೆ.
ಚೀಫ್ ಅಲ್ಲಿ
ಈ ಕಾರ್ತಿಕ್ ಅಸಿಸ್ಟೆಂಟ್ ಮ್ಯಾನೇಜರ್ ಕಡೆಯಿಂದ ಮಾರ್ಕ್ ಆಗಿದೆ.
ಯಾವ್ದು?
ಇನ್ಸೂರೆನ್ಸ್ ಕಡೆಯಿಂದಲೇ ಮಾರ್ಕ್ ಆಗಿದೆ. R3.
No, that is R3 is different.
Those all documents are submitted by them, the insurance company only.
ಯಾವ್ದು?
ಈ R3 series.
R3 series ಏನೇ ಇಲ್ಲ.
R1 is the letter issued by the insurance company. R2 is the letter from the RTO Murdabad.
ಅಷ್ಟೇ, ಅದ್ರ ಮಧ್ಯದಲ್ಲಿ ಇದು ಬಂದಿಲ್ಲ.
R3
ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಅನಾಮ್ ಮಷ್ಕೂರ್ ಅವ್ರದ್ದು ಬೇರೆ ಅವ್ರದ್ದು
It's the fake ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
It is
driving
belongs to
license
some other person.
ಅನಮ್ ಹೆಸರಲ್ಲಿ ಮಾಡಿರುವಂತದ್ದು that is in the name.
No, that is true. See, Anna Maskoor is the name of the lady. Our driving license ಅಲ್ಲಿ ನಿಮಗೆ ನಿಮ್ಮ ಡ್ರೈವರು ನಂದು ಅಂತ ಹೆಸರು ತೋರಿಸಿದ್ದಾನೆ ಆ ಹೆಸರಲ್ಲಿ ಅಂತ. Is it marked there?
ಅಲ್ಲ
ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇದೆಯಲ್ಲ,
ಅವನ್ ಲೈಸೆನ್ಸ್ ಇಲ್ವೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅವನ್ ಲೈಸೆನ್ಸ್
Number ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ ಅವ್ರು.
ಸಮ್ ಅದರ್ ಪರ್ಸನ್, ಅದನ್ನ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ. ನಂಬರ್ ಹೇಳ್ತಿರೋದು
ಇನ್ಶೂರೆನ್ಸ್ ಅವರಿಗೆ ಎಲ್ಲಿಂದ ಸಿಗ್ತದೆ?
ಇವನ್ ಹೆಸರು ಏನ್ ಹೇಳಿ? ಬೋಸ್.
ಫಾರೂಕ್.
ಇವನ್ ಹೆಸರು ಏನ್ ಹೇಳಿ?
ಫಾರೂಕ್
ಫಾರೂಕ್ ಸನ್ ಆಫ್ ಗೋಸ್
ಅಹಮದ್ ಅಂತ.
ಅವ್ರದ್ದು ಒಂದು ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ದಿಸ್ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ನಂಬರ್ ಈಸ್ ರಿಲೇಟೆಡ್ ಟು ದಟ್ ಲೇಡಿ.
ಹೌದು.
That is the fake.
Correct.
Whether this has been produced before the trial court ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇರೋದು.
They have not produced any document.
They produce
ಅವರೇ ಮಾಡಿರೋದು.
Original, blood.
that is their
ನನ್ ಕಂಟೆನ್ಷನ್ ಅಂತ ಈಗ ಅವನಿಗೆ ಇವ್ರು ಹೇಳ್ತಿರೋದು ನಾನು ಒರಿಜಿನಲ್ ನೋಡಿದೀನಿ ಅಂತ ಅಸ್ಯೂಮಿಂಗ್ ದಟ್ ಈ ಸೀನ್ ದಿ ಒರಿಜಿನಲ್. ಲೆಟ್ ಇಮ್ ಪ್ರೊಡ್ಯೂಸ್ ದಟ್ ಒರಿಜಿನಲ್, ಸೇಯಿಂಗ್ ದಟ್ he has verified that ಒರಿಜಿನಲ್ ಅಂತ. ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಿಲ್ಲ ಅವರು.
No, ಒರಿಜಿನಲ್ ಓನರ್ ಕೈಲಿ ಇಟ್ಕೊಳ್ಳೋದಿಲ್ಲ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್.
No.
He has shown and he has seen.
Please, ಅದೊಂದು ಕೊಡಿ ಅಂತಾನೆ. ಅದು that he has not placed before the court.
What is this? It is there in this.
Malad,
How it has come to that court?
ಅದನ್ನ ಕೋರ್ಟ್ ಇಂದ ನಾವು ಅವರಿಂದ ಸಮನ್ಸ್ ಇದನ್ನ ತಗೊಂಡಾಗ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇಂದ ತಗೊಂಡಾಗ ಪೊಲೀಸ್ನವ್ರ ಹತ್ರ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಂಡಿರೋದು, ಬಟ್ ಒರಿಜಿನಲ್ ಇಲ್ಲ, ಬರೀ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾತ್ರ ಇದೆ.
No, that is what fake. Where is that original owner will have?
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದನ್ನೇ.
ಒರಿಜಿನಲ್ ಯಾರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು?
ಓನರ್.
ಹೆಂಗ್ ಪ್ರೊಡ್ಯೂಸ್
ನಾನು
ಮಾಡ್ತಾನೆ?
ಅವನ ಡ್ರೈವರ್ದು ಅವನ ಹತ್ರನೇ ಒರಿಜಿನಲ್ ಇರುತ್ತೆ.
ಒರಿಜಿನಲ್ ಡ್ರೈವರ್ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಓನರ್ ಕೈಲಿ ಕೊಟ್ಬಿಟ್ಟು ಅವ್ನು ಓಡಾಡ್ತಾನ?
ಹೌದು ಸ್ವಾಮಿ, ಅದೇ ತರ ಮಾಡಿ ದುಡ್ಡು ನೋಡು.
ಅಲ್ರಿ, you have to carry your driving license
No,
when
no,
you
no,
are
but-
traveling.
ಹೌದು, ಅವ್ರು ತಗೊಂಡೋಗಿರ್ತಾರೆ.
See, he has to see
Kamlat.
whether
The procedure is like this, my lord. When the vehicle was met with an accident, they have to give the driving license, permit copy and the policy copy to the police. Only on the verification of those original record, that has to be, they will release the vehicle. This has to be done by the owner only, not by the driver.
Yes.
ಈಗ ಓನರ್ ಹತ್ರ ಇದ್ರೆ let him produce before the court.
ಕೊಟ್ಟಿದ್ದಾನಲ್ಲ ಅವನು.
ಅದು ಓನರ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದು it is not produced. ಇದು original.
there is a fake driving license which has been produced. It is the part of that, court records. They are saying that this is the document which has been shown by the driver saying that I have any driving license.
That is not their case, my lord. ನಮ್ ಡ್ರೈವರ್ ಹತ್ರ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಎಕ್ಸಿಬಿಟ್ P8 ಅಲ್ಲಿ ಸ್ವಾಮಿ.
ಫೇಕ್ ಅಂತ ಗೊತ್ತಾಗೋದು ಯಾವಾಗ ಅಂದ್ರೆ ಈ ಕೇಸ್ ಆದ್ಮೇಲೆ.
ಕರೆಕ್ಟ್.
ಮುಂಚೆ ಫೇಕ್ ಅಂತ ಗೊತ್ತಾಗ್ಬಿಟ್ಟು ಡ್ರೈವಿಂಗ್ ಕೊಟ್ಟಿದ್ರೆ ಅವ್ರು ತಪ್ಪದು.
ಕರೆಕ್ಟ್. ಮಲ ಇದ್ರಲ್ಲಿ ಇಶ್ಯೂಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಾನು ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬೇಸಿಂಗ್ ಆನ್ ದಿ ನಂಬರ್ ವಿ ಹಾವ್ ಫೈಲ್ ದಿ ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಅಲ್ಲ, ಅವರ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಇದೆ. I'll read that affidavit of the insurance company ಇದೆ. I further submit that DL produced the Farooq is fake one in the circumstances of the case. I submit that there is a violation of terms of the condition.
ಕರೆಕ್ಟ್. ಅದು
They
ಫೇಕ್
say
ಅಂತ
that
ನಮ್ಗೆ
in the affidavit.
No, why I am filing that affidavit? ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ ಅಡಿಷನಲ್ ರಿಟ್ರೇಸ್ಮೆಂಟ್. Your lordship kindly see the additional retreatment number which was given to the police. We have inquired with the RTO office where we can come to known to that it is issued to some other person. It is not to this person. Therefore, we have filed the return statement before the court.
They are collected from police station. You ಅಲ್ಲಿ police station collect ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ.
Oh, idರಲ್ಲಿ additional retracement was filed stating that it's a fake one. After that, Marat, no issues were framed to that extent by the court. Issueನೇ ಫ್ರೇಮ್ ಆಗ್ಲಿಲ್ಲ ರಿಗಾರ್ಡಿಂಗ್ ದಟ್ ಫೇಕ್ ಲೈಸೆನ್ಸ್ ಇಸ್ ಕನ್ಸರ್ನ್.
ಇಂಟರ್ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ಲಿ ಫ್ರಮ್ ಹೂಮ್ ಅಂತ
ಆಗಿದೆ
ನೋಡಿ ಸರ್. ಇಲ್ಲಿ
ನೀವು ದಯಮಾಡಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇಶ್ಯೂ ನಂಬರ್ 2 ನೋಡಿ.
ಇಶ್ಯೂ ನಂಬರ್ ಓದಿ ಸರ್. Issue number 2 ಅಲ್ಲಿ
Additional
whether the
ನಾನು
petition is
ಹಾಕಿರೋದು
entitled
ಯಾವತ್ತು?
ಅಲ್ಲ, ಸ್ವಲ್ಪ whether the petition entitled for complaint if so and from
Compensation,
whom and from whom.
liability or the fake license is concerned, issue has to be framed.
Where is that?
Written state, your lordship kindly see, written statement was filed by us before the court on
But binding is there ಅಲ್ವಾ?
ಯಾವ ಫೈಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ?
ಫೇಕ್ ಅಂತ ಬೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಇವರು
ಏನ್
ಕ್ರಿಮಿನಲ್
ಏನಂತ
ಫೇಕ್ ಅಂತ ಕೊಟ್ಟಿದಾರಲ್ಲ.
ಇಶ್ಯೂಸ್ ಇಲ್ದೇನೆ ಇದು ಇದು ಕೊಡಕ್ ಬರುತ್ತಾ ಸರ್? ರೀಸನ್ ಕೊಡಕ್ ಬರುತ್ತಾ?
ಅಲ್ಲ, ಏನ್ summary proceedings ಇಲ್ಲ.
ಹೇಳ್ತೀರಪ್ಪ ನನ್ಗೆ
Fake ಅಂತ
ಅರ್ಥ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಗ್ಲಿಲ್ಲ. ಅದು ಹೇಳಿ, ಅದೊಂದು ತೊಂದ್ರೆ ಇಲ್ಲ. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನನಗೆ 18 ನ
Yes.
7 ಅಲ್ಲಿ ನಾನು ಅಡಿಷನಲ್
See, in respect of that, let them frame that issue. You, for the payment is concerned, you have to pay that.
Correct.
Let
That's
them frame the issue, find out that he has taken all care for in terms of that judgment.
Basing
That
on that
can be-
third party is concerned, I am liable to.
Where is that judgment?
ಇಲ್ಲೇ ಈ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲದೆ ಅದಕ್ಕೆ ಇವ್ರು ಕೊಟ್ಟಿದ್ದ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನು ಅಂದ್ರೆ
Para 15.
ಇದರಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ವಾಸ್ ಮಾರ್ಕ್ ಬೈ ದಿ ಡ್ರೈವರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್. ಬೇಸಿಂಗ್ ಆನ್ ದಟ್ ಮೆಥಡ್ it is come, the issue was framed.
Before
Yes,
adverting the
that is it.
decision of the sworn,
Cyber attorney
please
ಇದೆ.
reference the facts emerging from the decision of tribunal is necessary. Tribunal appellant produce the driving license issued by the department. The driving license was found was fake. Senior assistant officer found so license was fake. This the appellant attempted to prove that he had a valid driving license issued by the licensing authority. The tribunal rejected the application filed by the appellant as producing the additional evidence. Tribunal noted that even otherwise that license which has been issued, whether is factor care would be until so and so license was renewed more than 2 years, 30 days of the tribunal has approved. ಇದಲ್ಲ ಯಾವ್ದಾದ್ರು judgment ಅದು?
ಅಲ್ಲಿ ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾನು ಅದನ್ನ
Which is that paragraph?
Paragraph 15 ಮೇಲೆ 15.
Yes, read.
As already pointed out, Supra, one seemingly valid driving license is produced by a person employed to drive vehicle unless such license is demonstrably fake on the face of it, warranting any sensible employer to make inquiries as to its genuineness or what the period, when the period of the license is already expired, or there is some other reason to entertain a genuine doubt as to its validity. The burden is upon the insurance company to prove that there was a failure on the part of the vehicle owner in carrying out due diligence approves such driving license before employing that person to drive the vehicle. Presently, no evidence has been placed on record where inference could be drawn that the deceased vehicle owner ought to have gotten verified Vijay's Paul driving license. Therefore, it was for the petition insurance company to prove willful breach on the part of the said vehicle owner. As such, no exercise was undertaken. The petition insurance company would have no right to recover compensation amount from the present owner of the vehicle. The impugned order passed by the Delhi Court holding to the effect, therefore, does not look.
Yes, let that issues be decided. Yes.
It is not the case, Lord, before the RTO also. This license was produced before the RTO. And RTO has admitted that fake license has been produced. Lord,
Now that
I do not having any license. The fake.
Now that there is admitted fact that there is a fake license has been produced, whether issue has to be framed and they have to prove that you have any knowledge saying that it is a fake, then only that burden will go. Otherwise, if they fail to prove that you have no knowledge, you have believed that it is a fake, it is an original, then they have to pay that. That is what the Supreme Court said. But that burden is lies on them. They have to prove that owner knows well saying that it is a fake, still he has allowed to drive that vehicle, then liability on you. If they fail to prove that owner has no knowledge, he has presumed that it is an original or it is an issued by that authority, then you are no negligence. Yes.
ಇಲ್ಲಿ ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಆ ಒರಿಜಿನಲ್ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಅಂತ ಅವ್ರದ್ದೇನ್ ನೋಡಿದಾರಲ್ಲ, ಆ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಒಂದ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಇಟ್ ಎಂಡ್ಸ್ ದಿ ಮ್ಯಾಟರ್.
Now there is a Xerox copy before the court. You have to prove by putting him in a box saying that he knows that it is a fake, still you have allowed.
Correct.
If you prove that, then he has to pay. Otherwise, as a layman, he can't see that how that license has to be there. He has seen the driving license, it appears to be driving license, he has allowed. then liability is on you. That is what that Supreme Court said.
has said.
Yes.
But as
In,
third party is concerned, let them.
that you, that I will,
Court will direct us.
he will direct you to pay that. Then that is subject to that additional issue has to be decided.
It is between the issued and the insurer.
Yes.
And nandu compare for enhancement during laid up period is not given.
No, tribunal ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಫೇಕ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಓನರ್ ಮೇಲೆ ಹಾಕಿ.
ಹೌದು, ಓನರ್ ಮೇಲೆ ಹಾಕಿದೆ.
Yes. Yes.
ನನ್ enhancement ಒಂದು ಗ್ರೌಂಡ್ ಅಷ್ಟೇ.
ಏನ್ ಇಂಜುರಿ ಕೇಸಾ?
Injury case ಅಷ್ಟೇ. He was employed in a Tata Power solar system and he was absent for about exhibit P14 lordship. He was off the work for 5 months, 20 days. ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಕಂಟೆನ್ಷನ್ ಇದೆ, ಸಾಹೇಬ್ರನ್ನ ಹೇಳ್ತಿರೋದಕ್ಕೆ ಇಷ್ಟೇ ಅಮೌಂಟ್ ಕಾದು. ಅದರ್ವೈಸ್ we have taken the contention is also as per the owner of the vehicle and the statement filed by them is contributed more than the driver. For his the petitioner negligence only the very accident was occurred. Petition negligence ಇಂದ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಅಂತ ಆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡು ಅದಕ್ಕೆ ಅವರು
ಅಲ್ಲ ನಿಮ್ದೇನು ಅಪೀಲ್ ಇಲ್ಲಲ್ಲ?
ಅವ್ರದ್ದು ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ. ಅವ್ರು ಹಾಕಕ್ಕಾಗತ್ತೆ. ಅವ್ರು ಅದನ್ನೇ ಕೇಸ್ ಅನ್ನು ಹಾಕೊಂಡು ಅವರು ಬಂದಿದ್ದಾರೆ. ಅದರಿಂದ ಅವರೇನ ಇವರು ಕೊಟ್ಟಿರೋ ಕಾಂಪನ್ಸೇಷನ್ ಸುಮ್ಮನೆ ಬಿಟ್ಟು ಅದನ್ನ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅಷ್ಟೇ.
No, that what is that? Where is that your contention that it is a negligence of that claimant?
ನಮ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲಿದೆ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಓನರ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
he was riding the motorcycle bearing registration Hosur Road electricity on that main road. When he reached that near electricity bus, the driver container lorry bearing registration number drove the same in rash and negligent manner, dashing the motorcycle due to impact fell down. But petitioner stated that immediately after the accident was shifted to the so-and-so patient and during the course of that take which revolves that circumstantial developments involving that left foot, both bones right form, involving injuries, left foot and so on. ಏನು ಸ್ಕೆಚ್ ಇದೆಯಾ?
ಸ್ಕೆಚ್ ಮೇಲೆ sketch exhibit P4.
Driver of the container lorry bearing this same in dash and negative dash motorcycle due to the impact on.
ಅದೇ
Who is RW1?
RW1.
One is the assistant manager of
Company officer.
RW2?
RTO.
RTO officer.
You are not examining that driver of the lorry.
No.
Then. ಲಾರಿ ಯಾವ ಕಡೆಯಿಂದ ಯಾವ ಕಡೆ ಹೋಗ್ತಾ ಇತ್ತು?
ಏನಕ್ಕೆ ಗೊತ್ತಿಲ್ಲ ನೀವು.
ವೇರ್
ಕಂಪ್ಲೇಂಟ್ ಪ್ರಕಾರ ನೋಡಿದ್ರೆ ಹಿಂದ್ಗಡೆಯಿಂದ ಹೊಡೆದಿದೀವಿ. ಕಂಪ್ಲೇಂಟ್ ಪ್ರಕಾರ ನೋಡಿದ್ರೆ
ಹಿಂದ್ಗಡೆಯಿಂದ ಹೊಡೆದಿರೋದ? ಇಲ್ಲ, ಹೌದೌದು. ಹಿಂದ್ಗಡೆ
ಹೊಸೂರು ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿ ಹೊಸೂರು ರಸ್ತೆ ಕಡೆಯಿಂದ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿ ಕಡೆಗೆ ಚಾಲನೆ ಮಾಡ್ಕೊಂಡು ಬರುತ್ತಿರುವಾಗ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿ ಬಸ್ ಸ್ಟಾಂಡ್ ನಿಂದ ಹತ್ತಿರ ನನ್ನ ಹಿಂದಿನಿಂದ ಬರುತ್ತಿದ್ದ ಕಂಟೈನರ್ ಲಾರಿ ಚಾಲಕ ವೇಗವಾಗಿ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ಡಿಕ್ಕಿ ಮಾಡಿದ್ರೆ ಕೆಳಗಾಗಿ ಬಿದ್ದು ಗಾಯಗಳಾಗುವುದು ತಿಳಿಸಿದರು ಎಂದು ನನ್ನ ಸ್ನೇಹಿತನಿಗೆ ಎಡಗಾಲಿಗೆ ಕೈಕಾಲಿಗೆ ಗಾಯವಾಗಿ ಸ್ವರ್ಶ ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲಾಗಿ ಚಿಕಿತ್ಸೆ
ಒಂದೇ ಸೈಡ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ರು.
ಹಿಂದೆಯಿಂದ ಬಂದು ಹೊಡೆದ್ರು.
ಹಿಂದಿಂದ ಹೊಡೆದಿದ್ದಾರೆ. IME ರಿಪೋರ್ಟ್ ಕೊಡ್ರಿ.
IME ರಿಪೋರ್ಟ್ ಲಾರಿ ಡ್ರೈವರ್ ರೇರ್ ವೀಲ್ ಮಡ್ಗಾರ್ಡ್ ರೇರ್ number plate were damaged. No damage to our vehicle.
He has denied, so also has not produced the police incident MNC extra donation in support of conduct of exam witnesses, the medical exam and so on. So the case of
IME ರಿಪೋರ್ಟ್ ಅಲ್ಲೂ ಏನಿಲ್ಲ, ನನ್ಗೆ ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜ್ ಆಗಿಲ್ಲ, ಬಟ್ ಹಿಂದ್ಗಡೆಯಿಂದ ಹೊಡೆದಾಗ ಡ್ಯಾಮೇಜ್ ಆಗಿಲ್ಲ. ಹಿಂದ್ಗಡೆಯಿಂದ ಹೊಡೆದಿದೆ ಲಾರಿ. ಹಿಂದ್ಗಡೆಯಿಂದ
ವೆಹಿಕಲ್
ನನ್ ಲಾರಿ IME ರಿಪೇರ್ ಮೊದಲು ಮೋಟರ್ ಸೈಕಲ್
rear wheel mudguard damaged,
The number plate damage.
ಹೊಡೆದಿರೋದಕ್ಕೆ ಸಾಕಲ್ಲ ಬಂದು
Vehicle damage ಆಗಿಲ್ಲ.
ಯುವರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. I will give the finding and conclusion. It is your negligent. ಅದಕ್ಕೆ I will give no further options.
Yes. Remanding the matter is futile exercise, Lord. He cannot, even the driver also cannot admit that I am given, by knowingly had given the license of fake.
Not driver.
Even owner also cannot admit it is a futile exercise.
No, you are not admitting. That is the, art of that lawyers to elicit from cross examination. Who will, any murderer will go to the box and say that I have murdered it or I have not murdered it. It is for the lawyers to elicit that, mister. You have to elicit that, therefore that they have to put in the cross examination box and elicit from you whether you have any knowledge or not. By cross examination, placing the material. Yes. What is that your enhancement, mister?
Enhanced my lord only during, he was off the work for 5 months, 20 days. Exhibit P14, lordship kindly. Exhibit P14 ಅಲ್ಲಿ.
P14 ಕೊಡಿ.
Report only was on leave 28/4/17 to 25/4/17. Sorry, 20.
ಎಷ್ಟು ದಿನ?
ಅಲ್ಲಿ 5 months, 20 days ಅಂತಾರೆ.
ಅದಕ್ಕೆ ಏನ್ ಟ್ರಿಬ್ಯುನಲ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Tribunal only 4 days ಅಂತ ನಿಮ್ಗೆ. 20.
What is the tribunal said?
Tribunal not given much.
ಏನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಒಟ್ಟು ಟೋಟಲ್?
Total, my lord. Tribunal awarded only loss apparent.
ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲೂನು ಲಾಸ್ ಆಗಿದೆ ಅನ್ನೋದ್ ಬಗ್ಗೆ ಏನ್
ಹೇಳಿದ್ದೀರಿ ನೋಡಿ.
ಎಂಪ್ಲಾಯರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ.
Actual
They have not stated that we have not paid the salary while
he was on medical leave ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಲೀವ್ ಅಷ್ಟೇ ಇದಾರೆ ಬಟ್ ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ.
Loss apparently encashment ಹೋಗುತ್ತಲ್ಲ.
Let him produce his passbook before the court.
Wait sir, wait. If he has not availed ಅಂದ್ರೆ loss apparently
ಕೊಡ್ತೀವಿ ಅಂತ ಕೊಡೋದಲ್ಲ.
Loss of immunities, future medical expenses. ಕೊಡಿ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ. ಅವರು ಕ್ಲೈಮೇಟ್ಸ್. What is his salary monthly?
47,000. ಅದರಲ್ಲೇ ಇದೆ salary slip. Total salary.
So I submitted that I was riding the motorcycle. He submitted the accident was not united. I have got so and so. It's in the date of the accident. I was ill and healthy. Emerging member of the family. Then injury is future. It is accident. I got due to the accident. It is a traffic police case so and so. The respondent RC owner of.
ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲೂ ಹೇಳಿಲ್ಲ ನನಗೆ ಸ್ಯಾಲರಿ ಲಾಸ್ ಆಗಿದೆ ಅಂತ.
You have loss of that income when you are in that hospital.
Loss apparently encashment.
8 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಅದನ್ನ, ನನಗೆ ಸಂಬಳ ಬರ್ತಿತ್ತು ಅನ್ನೋದನ್ನ. ಇದರಿಂದ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡಕ್ ಆಗದೆ ಇರ್ಬೋದು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ ಹೊರತು ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಆಯ್ತು ಅಂತ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
ಸರಿ, I have not received salary in that month.
ಅಲ್ಲ
ಲಾಸ್ ಅಂತ ಎಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬೇಕಲ್ಲ?
ಅಲ್ಲ ಲಾಸ್ apparently encashment ಆಗುತ್ತೆ. You could have surrendered that and.
Where is that? All has to be come in that evidence.
Really?
We can't imagine everything and grant it. It is come in that evidence, then we can.
Examined even employer also.
ಆಯ್ತು, ಎಂಪ್ಲಾಯರ್ ಹೇಳಿದಾರ ನಾನು ಸಂಬಳ ಕೊಟ್ಟಿಲ್ಲ ಅವರಿಗೆ ಅಥವಾ ಅವ್ರಿಗೆ ಲಾಸ್ ಆಯ್ತು ಅಂತ.
PW4.
By examining itself, he have committed a fault. He could have extracted from his mouth.
His salary was 57. ಮೆಡಿಕಲ್ ಹೋದ್ರೆ ಅವ್ನಿಗೆ ಸ್ಯಾಲರಿ ಬರೋದಿಲ್ಲ.
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬರ್ಬೇಕಲ್ಲ.
ಹೇಳಿದ್ರು
ಇಬ್ರು ಹೇಳಿ.
ವಾಸ್ ಮೇಂಟೈನಿಂಗ್.
What is that in other head? Pain and suffering.
ಫ್ಯೂಚರ್ ಲಾಸ್ ಸಫರಿಂಗ್ಸ್ ಬರೋದಿಲ್ಲ.
Pain and suffering 60 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
ಎಷ್ಟ್ ದಿನ ಇದ್ರಿ ನೀವು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ?
10 days. He was in 16/5, second patient, 28/4 going to
Future medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of immunities.
inpatient 28.
28/4 ಇಂದ 5/5.
28/4 ಇಂದ
Pain and suffering ಬೇಕಾದ್ರೆ ಒಂದು 40,000 ಜಾಸ್ತಿ ಮಾಡಿ ಅದೊಂದು ಲಕ್ಷ ಮಾಡ್ಬೋದು. So and so learned counsel appearing for owner of the offending vehicle has contended that the driver, the owner was not aware that driving license produced by driver of the offending vehicle was fake one. He was believed that driving license driver holding the driving license is valid driving license, therefore he has been allowed to drive that vehicle. He further contended that the insurance company has not proved that driver has a knowledge about that fake driving license and he was allowed to allow the driver to drive that vehicle. Therefore, tribunal has error in exonerated that insurance company. In support of his contention, he has relied on judgment of Apex Court in case of IFCO Tokyo General Insurance Company versus Geeta Devi and others. SLP 1991992 of 2023. Disposed of on 30th October 2023. Secondly, he has contended that considering that injury suffered by the claimant and evidence of the doctor and medical records, the overall compensation awarded by the tribunal is on higher side. Shri Shivanegowda learned counsel appearing for insurance company has contended that insurance company has filed in a written statement has taken a specific contention that driver of the offending vehicle was not holding valid driving license. The owner of the offending vehicle was not aware that driver was not having driving license. He has been allowed to drive that vehicle. Since insured has violated the policy condition, insurance company is not liable to pay any compensation. He further contended that tribunal has not framed any issue regarding that fake driving license to prove that the owner of the offending vehicle has believed that driving license produced by the driver of the offending vehicle is valid driving license. Secondly, he has contended that considering that the evidence of the doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Shri so and so learned counsel appearing for insurance company, the claimant has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of
10 days.
Inpatient for a period of 10 days. He has been advised to take rest for a period of 5 months. He has suffered a lot of pain during the treatment. The compensation awarded by the tribunal for pain and suffering, loss of amenities and other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Heard the learned counsel for the parties, peruse judgment and award and original records. The case of the owner of the offending vehicle that he has believed that driving license produced by the driver is a valid driving license. After taking all care, he has been allowed to drive that vehicle. The insurance company has filed a written statement and produced that document to show that the driving license produced by the driver of the offending vehicle is fake one. He was not having any driving license as on the date of the accident. The apex court, in case of Geeta Devi and others, has held paragraph 15 extractment. In view of the above judgment, the burden is upon the insurance company to prove that there was a failure on the part of the vehicle owner in carrying out due diligence, approach such a driving license before employing that person to drive the vehicle. Since there was no issue has been framed in respect of these aspects, the matter requires to be remitted back to the tribunal to frame an issue in respect of the above. And decide the same after giving an opportunity to both the parties. In respect of claimant is concerned, in view of the judgment of apex court in case of Poppu, the insurance company is to pay that compensation with liberty to recover the same subject to that the tribunal deciding on the issues. In respect of quantum is concerned, due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 10 days.
Exhibit P18 alone, photographs ಕೊಟ್ಟಿದ್ದಾರೆ ಅದೊಂದು ಬಹಳ ಸಿವಿಯರ್ ಇದೆ.
Yes, he has also produced exhibit P18 photographs to show that he has suffered lot of pain during the treatment. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that compensation awarded by the tribunal for pain and suffering has to be enhanced from 60,000 to 1 lakh. In respect of other head, compensation awarded by the tribunal is just and reasonable. The insurance company is directed to deposit entire compensation amount with interest within 6 weeks from date of receipt of a copy of this order. Liberty to recover subject to the decision of the tribunal in that demand matter in respect of that issues. Yes. Amount in deposit is, ಯಾರು ಡಿಪಾಸಿಟ್ ಮಾಡಿ?
ಟ್ರೈಬ್ಯುನಲ್ ಓನರ್ದು ಅದು ಹಂಗೆ ಇರ್ಲಿ.
Tribunal amount in deposit by that owner will transfer to the tribunal. If he succeed, then that will be recovered to him. Just otherwise, will be withdrawn. You can be withdrawn that amount. Yes. ಯಾವ್ದಕ್ಕೆ? Serial number? Yeah. Yes, you are appearing in that, Ele Shivanagowda. His case also you are appearing or Arun Pannappa?
Both cases is the big task. ನಾನು ಹೆಂಗೆ ಹೇಳಕ್ಕಾಗತ್ತೆ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ಈ ಸೀನಿಯರ್.
ಅಲ್ಲ ವಕಾಲತ್ ಹಾಕಿದಾರ, ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ನಾನು ವಕಾಲತ್ ನನ್ನ ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. ಬಟ್ ಆ ಕೇಸಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿದಾರೋ ಅವ್ರು ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಅರುಣ್ ಪರಪ್ಪ ಹಾಕಿದ್ರು.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ ಬಿಡಿ ಸ್ವಾಮಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ನನ್ನ ಹೆಸರು ತೋರಿರಿ. ಬೇಕಾದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಪೇಮೆಂಟ್ ನೀವು ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ.
Yes. ಅದರಲ್ಲಿ office is directed to show the name of BC Shivanagowda for R2, delete the name of Arun Pannappa.
ಇದು R1 ನಲ್ಲಿ accept notice
ಡಿಲೀಟ್
ಇದರಲ್ಲಿ 60
ಜೊತೆ
ಅಲ್ಲ, ಜೊತೆಗೆ ಸೇರಿಸಿದ್ರೆ ಇಬ್ಬರಿಗೂ ಬರುತ್ತೆ ಅಷ್ಟೇ. ನಾವು ವಿಲ್ ಶೋ ದಟ್
ಅವ್ರ ಹೆಸರು ಮೊದಲನೇ ಕೇಸಲ್ಲಿ ನಾನು ಒಂದ್ರಲ್ಲಿ ನಾನು ವಕಾಲತ್ ಹಾಕಿ,
ಒಂದ್ರಲ್ಲಿ ನಿಮ್ದು ಹೆಸರು ತೋರಿಸ್ತೀವಿ, ಒಂದ್ರಲ್ಲಿ ಅವ್ರದ್ದು ಹೆಸರು.
ಎಸ್ ಅಡ್ರೆಸ್ ದಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಂಗೆ ತೋರಿಸಿ ಏನಾಗಲ್ಲ. ಅವ್ರ ಹೆಸರಲ್ಲೇ ಬರ್ಲಿ ಅದು.
ಹಂಗಾದ್ರೆ
ಅರುಣ್ ಪನ್ನಪ್ಪ ಹೆಸರಲ್ಲೇ ಬರ್ಲಿ.
ಶಿವನಗೌಡ ಅಂಡ್ ಅರುಣ್ ಪನ್ನಪ್ಪ ಸಬ್ಮಿಟ್ಸ್ ಅಂತ ಬರ್ಬಿಡಿ.
16.1 ನಲ್ಲಿ accept notice for R1.
16.1 ಅಲ್ಲ, you will take notice for R1.
ಹೌದು.
ಇವ್ರದ್ ಕೇಸಲ್ಲಿ
Climate.
Yes, Gopal Krishna N is the undertake to appear for R1. ಅದರಲ್ಲಿ ಎರಡು ಕೇಸು ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಂತ ಬರ್ಬಿಡಿ. Yes. All pending applications are disposed.
Serial number 17, Vivekananda TP for appellant, C.R. Ravishankar.
Yes, Mr. Logan.
Case of injury, minutes.
Yes.
The date of accident is 24/6/2015.
2015.
The appellant is aged 35 years as on the date of accident.
25.
35.
Yes.
That's he was hospitalized for more than 4 months, 4 months, 2 days.
Yes.
The doctor has assessed the disability to the particular limb at 74% minutes.
Where is that?
Please minutes.
Discussion of the tribunal.
Page at 24 minutes. Page 23 bottom and 24.
Yes. Yes.
And, these are the dates on which he was hospitalized.
Yes.
Then the doctor says minutes produced by the court commissioner, which are exhibited in the C series, undisputed, and the petitioner was treated as inpatient for about 4 months, 2 days, and he has undergone so and so. But as regards
disability discussion.
As regards the disability, page 27.
Para 27.
Para 27, page 27. The petitioner in his petition has claimed that he has suffered permanent disability due to the accident. The petitioner has also reiterated this fact when he was examined as PW1. When I analyze the cross-examination of PW1, nothing much is elicited to disprove the contention of the petitioner. On the other hand, the petitioner has examined the doctor who is said to have treated him by taking a commissioner. The doctor is examined by the commission and he has assessed the disability of right lower limb of the petitioner at 72.9% and 24.3% for whole body. He has produced 6 documents which are marked at exhibit C1 to C3. Is the C4. The exhibit C3 is the disability assessment. The doctor is cross-examined by the learned counsel for the respondent number 2, and in the evidence it is suggested to the doctor that no disability is suffered by the petitioner. When I analyze the exhibit C3, which is disability assessment, the doctor has assessed the whole body disability of petitioner to 24.3%. In the evidence, the doctor has stated as how he has assessed the disability, wherein the loss of mobility component of right lower limb, muscle strength and stability component is assessed, and the doctor has given a conclusion.
Now, whether this assessment of the doctor has to be accepted as it is or it requires to be reappreciated is another question. In assessing the evidence of the doctor, the parameters are laid down in so and so, so and so. Next, let's keeping this guideline given by the Supreme Court in my mind. Now let me analyze the permanent disability as contended by the petitioner in respect of his loss of earning capacity. Admittedly, the petitioner is a flower vendor. As per the medical record, the age of the petitioner as on the date of the accident was 35 years. According to the petitioner himself, he was a flower vendor, and apart from this, no other avocation is pleaded by the petitioner. In view of this fact, even though the doctor has assessed the whole body disability at 24.3%, as a owner of the land, it is always possible for the petitioner to continue with his avocation, if not to the full extent with a reduction of ability also. The petitioner would be in a position to carry on his avocation in the future also. That is to say, only to some extent the disability that has crept into the petitioner would be responsible for the hindrance of his earning capacity. Keeping these facts in mind, I can safely assess the disability of the petitioner at 18% rather than 24.3%. The doctor has virtually reassessed the disability on the ground that he is, and it is nobody's case that he has an agriculture land, he is cultivating the land and he is growing flower. It is his case that it is a flower vendor.
Yes.
For that, my lord, he has to travel and he has to stand and he has to undergo, my lord, the other this one.
Yes.
Therefore, reduction on that score, my lord, may not be correct. My lord.
Yes.
The count that he owns the land, he can cultivate the land and
Yes.
that may not be correct.
Yes.
And as regards the income is concerned, the accident is of the year 2015. The tribunal has considered the income at 8,000 per month.
Yes. Have you produced any documents?
No, my lord.
Yes.
It is notionally assessed by the tribunal.
Yes.
At page number
Pain and suffering, 25,000.
25,000 is granted.
Medical expenses towards conveyances, loss of income during the later period. ಎಷ್ಟು ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ?
The tribunal has granted for about 7 months.
7 months ಕೊಟ್ಟಿದ್ದಾರೆ.
7 months ಗೆ ಅವರು 21,000 rupees ಕೊಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ಯಾವ್ದು attendant charges. He was hospitalized for 4 months, 2 days. And for attendant charges, 21,000 rupees ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಿ?
Para 23, page number 17 minutes.
Towards loss of future income ಆಯ್ತು. Typical disability affecting the amenities has to be enhanced. ಎಲ್ಲಿ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ? ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಇದೆ. ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಎಲ್ಲಾ ಸೇರಿ 44,500.
ಇಲ್ಲ, ಇದರಲ್ಲಿ 2 petitions ಇದೆ. Lordship may kindly see page 17.
ನಿಮ್ದು ಯಾವ್ದು?
ಇದು 695. 695 ಒಂದು ಇಲ್ಲಿಗೆ ಎಂಡ್ ಆಗುತ್ತೆ.
95. Yes, 695 I have seen.
695 ನಲ್ಲಿ
44,500 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್, ಕನ್ವೀನಿಯನ್ಸಸ್, ನರಿಶ್ಮೆಂಟ್ ಎಲ್ಲ ಸೇರಿ.
Please, minutes.
Okay. Yes. What is that interest awarded?
The interest is at the rate of 6%.
6%. Correct. Yes, that's all.
Please, minutes. Let's insofar as not the loss of earning during later period is concerned, the hospitalization itself is 4 months, 2 days. Court has considered for 7 months.
7 months. ಕೊಟ್ಟಿದ್ದಾರಂತೆ. 3 ತಿಂಗಳು ಎಕ್ಸ್ಟ್ರಾ
extra ಕೊಟ್ಟಿದ್ದಾರೆ. But insofar as attendant charges is concerned, only 21,000 is awarded. Para 23, page 17.
Para
23 minutes of the judgment. 21,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 4 months, 2 days. At least 500 rupees per day. Let's pay.
1,000 per day medical attendance charges. This appears to be exorbitant. In my opinion, medical attendance charges 21 is fixed. That would be fair and just. 21,000 ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
ಇನ್ ಬಾಕಿ ಇದಕ್ಕೆ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ? 44,000 ಏನೇನು ಕೊಟ್ಟಿದ್ದಾರೆ? ಅದು 44. 44,500. 300 only under that head. Accordingly, inclined to grant compensation only under that.
Loss of the pain and suffering, he has undergone surgery and he was hospitalized for 4 months, 2 days. 25,000 is very meager, so
Yes,
that needs to be
yes, we'll consider.
Please.
Study. So and so learned counsel appearing for the claimant has contended that due to the CH-10, claimant has suffered grievous injury. He was inpatient for a period of 4 months. He has suffered lot of pain during the treatment. He has examined the doctor.
It's in the index, in the annexure to the judgment,
Yes.
it is not reflected, my lord, insofar as doctor is concerned. But
Doctor
doctor has been examined.
ನಾವು ಇದಿದ್ಯಾ ಎಕ್ಸಿಬಿಟ್ ಡಾಕ್ಟರ್
PW2 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
PW2 ನಾ ವಾಟ್ ಇಸ್ ಹಿಸ್ ನೇಮ್?
His name is Dr. Vivekananda BR.
ಇಲ್ಲಿ PW2 ಬೇರೆ ತೋರಿಸಿ ಇನ್ನೊಂದು ಕೇಸ್ ಇನ್. Yes. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered disability of right lower limb at 72.9%, 24.3% for whole body. Tribunal has assessed whole body disabilities 18% is on lower side. He further contended that at the time of the accident, claimant was earning 20,000 per month. Tribunal has assessed notional income of the claimant as 8,000 per month is on lower side. Lastly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 4 months. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, Sri Ravi Learned Counsel appearing for insurance company has contended that considering that evidence of doctor and injury suffered by the claimant and on the basis of claimant and his age and avocation, the tribunal has rightly assessed whole body disabilities 18%. He further contended that even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income of the claimant as 8,000 per month. Lastly, he has contended that considering that evidence of Dr. PW2 and considering that medical records and injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses just and reasonable. Hence sought for dismissal of the appeal. Heard the learned counsel for the parties. Perose, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 24/6/2015 due to rash and negligent driving of driver of tractor and trailer bearing registration number KA11 T9525-9524. Due to that accident, claimant has suffered the following injury. Dr. Vivekananda has been examined as PW2. In his evidence, he has deposed that claimant has suffered disability of right lower limb to the extent of 72.9% and whole body disabilities is 24.3%. Considering that evidence of doctor and injury suffered by the claimant and considering his age and avocation, I am of the opinion that whole body disabilities has to be assessed 24%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2015, notional income has to be considered as 9,000. At the time of the accident, He was aged about 35 years. Multiplier applicable to that age group is 16. Accordingly, loss of future earning has been reassessed as follows.
9,000 into 12 into 16 into 24%, 4,14,720.
Due to that accident, claimant has suffered the above said injury, was inpatient for a period of 4 months, 3 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 25,000 to 50,000. For loss of immunities from 20,000 to 40,000. Loss of income during the later period has to be granted for 7 months. Towards attendance charges, conveyances, nourishment has to be enhanced from 44,500 to 55,000. Other head compensation awarded by the tribunal is just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified.
Public.
ಇದೆ ಬಿಡಮ್. ನೆನ್ನೆನೆ ತಗ್ಸಿದೆ.